17 to rewear a suit?
I was like, nah, I have no other options.
They make it to Florida?
Well, the closest one is the law. I mean, I didn't see it, but this one is not nice. Pretty good.
Plus, it's like quite the drive to take for the chance that a suit might work. So.
Exactly.
You'll get down there eventually.
Yeah.
They are.
Okay. And I just wanted to remind about the name.
Trying not to use her name.
Thank you.
We'll do what we can. Thank you.
DA and stipulation for all the exhibits.
21st.
Yeah, that's a job unto itself.
Cole, I need your autograph.
fight facing the jury for.
I think you just put there that you can.
Okay. 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 So there's no reason. There's no reason it can't be termed slightly, right? No. Okay.
So the parts of the exhibits that were redacted, do you know which numbers those are?
So there's one with a post-it with post-its across
So
the
I have
bottom.
some
That one
stuff
we just need to
put on
cut
there.
that exhibit. You don't want that?
No.
I want to get that.
But I will promise I'll keep it right.
Oh yeah, that one works.
I just want to make sure that does not go to scam.
Find me, it's involved with Steve Lex, so find me the texts from 511 to 566 today.
The 18th?
811 through the 16th. I don't know what exactly we put on it.
That was a
I think it should be in the 300s.
Good morning, Judge.
How are you doing?
Good.
Good morning.
Here it is.
How are you doing?
Hey, Judge.
Surgery, you gotta get rid of this, so
What's
that
that?
put it in the sticker on here. Redacted. So you're gonna do a new exhibit sticker.
The cell phone exhibits? Yeah. That's the only one, right?
That was the only one that had to be redacted. We simply didn't submit one of the pages on the other one.
That one be removed?
No, the exhibit itself stands. We just didn't, instead of giving all 4 pages, we took the page that was objectionable, is my understanding.
Thank you. You're good.
Oh, this looks all good to me.
Okay. I have a good record. It's warm in here today. Don't think we're later. Thanks, Judy.
Hey, Jessica,
Yep.
I'm looking here, this, State's Exhibit 109, doesn't say that it was received.
So, well, people testified about this, the reddish stains. That's not the same one, that's the A1.
So that's A2?
It's a something. Because originally we had marked all of the,
Okay, so this is A2 then.
that could be A2. A1 was received, but the other ones that,
A2 was the only other one that was swabbed, that wasn't tested.
Right.
Yeah.
Everything else was just chemically tested.
yeah, so, yeah, that's A2.
Alright.
I just had marked everything just in case, and
Okay,
then,
I just
need something
wanted to
renamed?
make sure.
no, I don't think so.
No?
Because if you look at states 102 through 104 or 05, those are other things that we mentioned in the trial, but we didn't actually move in evidence because they were pointless.
Yeah.
So, and if you recall, remember I missed 3 numbers, which is why there's a weird space.
Yeah. Okay, I just wanted to make sure.
Yep, nope, that's not A1. It literally just called letter, and we put
put our heads together and have no concept of what that exhibit was.
It wasn't introduced, right?
Yes, no, right. No one believes we moved it in. We just.
But I won't. One time I interrupted your predecessor and stopped him in mid-word. But
Is the defendant here? Do they know to bring him at 8:30?
I beg your pardon?
They have to make sure the jury's fully
Okay,
here.
is the jury here?
I can't do anything until he gets here. Yeah. And yesterday afternoon I did send draft number 2 of the instructions and draft number 1 of the proposed verdict forms. Did everyone get a chance to look at those?
I received nothing. Oh, that's an honest statement. I did not receive anything from you.
That's not good.
I just see now an email from 413, but honestly, I did. Yeah.
Well, the instructions are as they were given. This is the written form. And the only significant change from the draft number 1 is the addition of the ones that hadn't been in before, the removal of the references to defendant's testimony, 205, and the others you requested other than prisoner as a witness. And those are the only changes on the instructions. The verdicts are very, very common.
Yeah, I just reviewed the verdict forms. Look good to me.
Okay, the district attorney's giving me a thumbs up, so that's good. Are we ready for the jury?
Yes.
Yes, Judge.
All right.
Hello?
Good morning. Would you come down, please?
Yes.
Thank you. In terms of steadfastness, we're going to hear the closing arguments of the attorneys, and because this is not evidence, no note-taking will be permitted for the duration of the trial. We follow the classical format, debate format in the courts. The district attorney bears the burden of proof, and because of the allocation of the burden, will be entitled to give the first argument, and then he will be given a second rebuttal argument, which will be confined to answering the defense in its presentation. So it'll be the state defense and then the state again. And then I'll give you those couple of instructions, and the case will be turned over to you. Anybody have a problem having some food brought in? Okay, I'm going to do that then. Surprise. So take care of that, please. And with that, Mr. Gravely, you have the floor.
Thank you. Your Honor, counsels, ladies and gentlemen of the jury, I just want to please start by expressing, without really having the words for it, the gratitude that I think we all feel for your service on this case. I mean, so many weeks, way beyond what you were expected to do. So just as simply as I can, please let me just be part of expressing my just profound gratitude for your time and your service and your consideration in this case. I want to start with just a couple of housekeeping things about the charges, and then I'm going to get into the crux of the argument. A couple of the charges are stalking offenses, probably not something you think about all the time. Stalking involves two or more things happening, so a course of conduct where two or more things are done by the defendant. We're talking in our stalking allegations today about the April 24th peek-in, using his daughter as one of the peek-ins over at Sadie's place, the planting of a phone to track her on May 8th, again peeking in or listening in on May 13th at Rosalio Gutierrez's place, and then of course the homicide committed on May 17th. So we're asking the court, you guys, to consider all of those things as acts of stalking, as well as the emails sent and the texts sent, the communications, the recordings of Sadie Beecham as well. So what needs to happen for a stalking is you need to have an impact that a reasonable person would have, and it's called, the part that we care about is serious emotional, suffering serious emotional distress, which means that you have to feel harassed or tormented, that a reasonable person has to feel that. The stalking statute also requires that the individual involved, the person who is suffering at the other end of that, also has to suffer serious emotional distress. In other words, personally feel that they have been harassed or tormented. And you heard in the texts and some of the discussions, both Rosalio and Sadie wrestle with the consequences of this, right? Talking about it. Sadie has a text where she says, I hope this, doesn't mean that you will, want to end this relationship because of this harassment. At points, Rosalio is trying to be comforting to her. At points, he is feeling aggressive, right? I'd like to go break this guy's legs. What's his address? The kind of human emotions that people have in response to feeling like their personal liberty, their space, everything that they sort of care about in their privacy is being compromised by this other person. And so those are the emotions that both you heard expressed in the text messages from both Rosalio and Sadie, and the question of what a reasonable person would think about that. Another just small housekeeping along those lines is hiding a corpse. We're suggesting to you that when Rosalio Gutierrez is murdered on the 17th at around 10 p.m., the placement of his body in the defendant's minivan is the beginning of a long stage of hiding a corpse. And so that is where that hiding a corpse begins in terms of our allegations to present to you today. So I want to first cover this idea that there are two separate but combined sets of facts that allow you to know that there is proof beyond a reasonable doubt that Rosalio Gutierrez was murdered on May 17th, 2020 at around 10 p.m., just around 10 p.m. at his own apartment. And I say that because there are two things that happen. One, there is a bloody, bloody scene. A scene that has pools of blood that I'm going to talk about a little more in a second. But also, there are the circumstances of Rosalio Gutierrez's absence from the life of everyone he cared about and who cares about him. Rosalio's phone shows he gets home at about 9:08 p.m. He's just dropped his kids off back at their mom's. He's expecting Neridia Macias. Her last text to him is at 9:37 p.m., and that text is never answered. She stays at the apartment building. Remember, she's at the wrong building. She doesn't see what is happening. But she stays for about a little more than a half hour, and she's texting and calling, essentially expressing to him, I'm here, what's going on? And none of those are answered. None of those are viewed. So at this point, from 9:37 on, Rosalio Gutierrez is no longer answering anyone who is concerned about him or interested in him or who care about him and his life. And now, ladies and gentlemen, we are 1,039 days later. And what I just described to you is still the circumstance today. Rosalio loved his kids. He loved his mom, who he was in communication with as a guy almost 40 or around 40 every day. Every day he was in communication with his mom. And that suddenly ended at just around 10 p.m. on May 17th. He planned and proudly was ready to coach his promising son in baseball. And he never got a chance to do that. He had a summer camp scheduled for him and his children called, and it's a summer camp that's common for folks in Kenosha. And that summer camp was already planned. It's in his calendar, and that never occurred on the 19th of May. He no longer attended any of the holidays or events or visits. He no longer had any experiences with his children. He was a father whose daughter had a little love note to Dad on the pillow when she left. He was a father whose son shared his love of baseball and emulated him in every way he could in that love. And all of that has been gone for every day since May 17th, 2020. So combined with that bloody scene, you as a jury know he was murdered. You know that because those two things together show you that he is gone. So you know that there is a quantity of blood and a magnitude of blood in this case which certainly tells that story. There is blood pooled on the floor by the couch. There's blood pooled on the couch itself. There's blood sprayed on wall after wall and on the ceiling in multiple areas and on almost every surface of his main room and the hallway by his door. There is a quantity and magnitude of blood which is absolutely consistent with Rosalio Gutierrez being murdered there at his own apartment. And every bit of that blood that's been tested in those different areas all come back to the DNA of Mr. Gutierrez himself. So that quantity of blood and his absence from any contact, any social media, any financial records, any of the people who care about him, any phones, any in-person contact, all of that is gone over those 1,039 days. And so we know and can say as a legal conclusion that a reasonable jury will find that he is murdered. The blood and his absence both tell us that story. So what else do we know about this crime based on the evidence that's been presented in this case? And I want to suggest to you first that the next obvious and real conclusion is that this is a highly planned, thought out, and executed crime of murder. And so I want you to think about who there is in this case who has shown a propensity, right? Who has shown day after day in the conduct that we have outlined patterns of that sort of planning, that sort of obsessive conduct, that sort of refusal to follow any of the limits and rules that most of us would govern ourselves and who we are willing to use to accomplish our goals in our lives. So when I say who, I mean, of course, the defendant, right? Because here's what we know about him in terms of other things happening in the very few weeks that we have a glimpse of his overwhelming, out-of-control, no-limits jealousy towards any new love life for his ex, Sadie Beecham. What are those pieces of evidence I'm suggesting are signs of an obsessed planner that are the signature of this crime of murder? Well, one is Olivia, and this is uncontroverted evidence, right? This is unchallenged evidence in this case in the record. The daughter tells you that her father had conceived a plan with her. And it is a truly sinister plan of having there be a day when Sadie had brought the boys and the daughter over to visit their dad. And then when they figured out that Sadie was gone to visit her new love life, then those children would be returned. And when those children would be returned, the daughter would make a call to her father saying, fraudulently, falsely, well, I don't know where mom is, we are abandoned. And then he would falsely save the day. He would report this. She would be a child neglect mom because of the false information and the horrible use of an 11-year-old girl to accomplish his sinister aims. Who comes up with a plan like that? Who offers that as something that an 11-year-old should do for them? What sort of mind is capable of putting that plan and that use of an 11-year-old out into the atmosphere as something real? And I'd suggest to you it's the same person who could commit and did commit this homicide. So what other evidence do I have that, this is a obsessive planner, knows no limits? Well, what about the daughter telling you that when she was urged to peek in that window at her mother, when her mother, a consenting adult, did not have the children over, I'm talking about April 24th, when Rosalio is over at Sadie's home, it's the evening, neither of them have their kids with them, they're consenting adults, and they're in the living room. And when the daughter peeks up over that into the window to look in at her mother, which the father has urged her to do, the defendant tells her, think about this as a small snapshot in this case. He tells her, hey, keep your shirt up so that you don't steam up the glass so that you can't be detected from inside. Who would even have ever thought of that? What sort of an obsessive planner has that in their brain to share to an 11-year-old? Who is there who is already thinking about cover-ups and avoiding detection in that kind of profound way? It's a snapshot, right? It's just a little moment. And, of course, it is the kind of thing I'd suggest to you an 11, 12-year-old would never have the capability of giving that kind of detail in a lie or frame up or some kind of false story that she was put up to. Think about all the computer files that this defendant has that are about Rosalio Gutierrez and the high amount of planning that is. All those snapshots that he stored on his computer, all the lookups he had done of this individual, and didn't just peek at them, stored them. Had a file for them. Had a file where he included the picture of the tracker. What about buying trackers at a point where you feel like you're losing control of Sadie Beecham and even though you have another girlfriend that you are wanting her to have no one in her life? The buying of the tracker itself is a sign of a planner who's willing to put a lot of obsessive effort into this. And then what about May 13th? You get your directions on your phone. Your phone puts you on May 13th right where Rosalio Gutierrez lives. And then you text Sadie the same sentence that has just come out of Rosalio's mouth. So you're overhearing from right on that patio what's being said inside. Okay? Doesn't that yell out to you as a jury that that's a dry run? That that's a reconnaissance mission to figure out what the terrain is, so that the next time you come down, just 4 days later, you don't have to have your phone, right? You already know now how to get there. You've got the directions from your prior visit. You know how close your van will have to be when you kill this man to be able to remove his body from that location. You already have had a chance to think about and put together a plan that is informed. This is the planner that is necessary to carry out the plan of what you have heard about the evidence that happened on May 17th. And you know that this is a highly planned incident. You know that because the defendant leaves his phone behind in Mech 1. But he's also off the grid. He's not answering or texting or web searching. There's none of the usual activity happening on his phone. But he leaves it. And what that tells you, folks, knowing this obsessive planner in terms of the other glimpses we get at him, is that this is done for a purpose. Because he must be able to cloak where he goes, to hide where he goes, because of what he will do next. And so if that is the plan, of course he brings gloves. Okay? Of course he brings the weapons he needs to be able to accomplish this murder. Of course he brings the tools that he will need to dispose of this body, right? The bags, any other tools he needs to finish that. Of course, this obsessive planner, this person, will have already thought about what the location is that he will place this body. What the dumpster is, or what the location is, will be something that has no connection to him, that does not require him to in any way deviate from any kind of timetable or plan. All of those things will have been thought over. Is it an accident that he picks a day of a heavy rainstorm when people aren't going to be out and about, or certainly aren't going to remain out and about? I would suggest it is not an accident. So what happens? Well, the first thing we know is that in that hallway of Rosalio's apartment, the blood tells a story. And I'm going to suggest to you a reasonable thought process for you is it tells a story of a blitz attack in that hallway. Someone hiding, ringing a doorbell, probably having no idea that Rosalio is expecting company, right? And so is a person who's going to be prone to open the door. But it is going to be somebody who Rosalio doesn't know. Because you're not going to blitz that person in the hallway and cause all that blood. If you know him, you're going to be inside. You're going to figure out a way inside to get yourself into a more private location. So it's going to be someone who will not be welcome and who you don't know. Rosalio doesn't know. And so you know from the evidence in this case that there are at least 2 blows, blunt force trauma blows. A hard object hitting Rosalio Gutierrez in a way that makes him bleed. And not only makes him bleed, but makes his blood fly into the air to hit doors. And you know that when that blood flies, that door in the hallway is open. So Rosalio has not yet managed to go back in or to close that door when he is first attacked. And so that is the blitz attack that evidence leads you to. Remember that Officer Van Wee told you that he knows that door was still open at some of the points that the blunt force trauma blows are happening because there's blood on the interior of the entry part of the door. And that when that door is closed, either in the hallway or inside, that part of the door would not be exposed. So you know there's a blitz attack. And you know there's a couple of blows that happen out there. And then you know whoever is the attacker, the defendant in this case, the planner, needs to get himself in that apartment. And why is that? Well, he needs to get himself in there because 2 neighbors, at least, may start to hear a ruckus, right? A neighbor, when she is talked to in some detail, when it's not just a cursory sort of canvas, but when she's talked to in some detail, says after 9 or around 9, I hear a scream in the hallway of pain and surprise at a time period right around May 17th. Marissa Swanigan, who testified, told you between 10 and 11 on May 17th, I heard a loud banging for about 5 minutes against my living room wall. Something big was forced up against the wall. Now the defendant knows that he's got to hurry. Okay? The blunt force trauma attack to get Rosalio Gutierrez in a position where he can be killed, that blunt force attack has to be finished as quickly and efficiently as possible because the defendant has no idea whether someone will come any moment soon. All of his preparation needs to be hurried. And so there are continuing blows. There's another blow now on the inside at the door that is a blunt force trauma. Again, blood flies onto the wall, onto part of the ceiling. Over by the dining room table, so a few steps further into the apartment, over on the wall over there, there's a table over there, and that also has a blow that is suffered right by it. And then there are additional blows at that table right at the entryway, and then another blow at the couch. These are all blunt force trauma blows, and Officer Van Wee said conservatively there have to be at the minimum 6 of those based on their locations and the differing blood that has splashed and spattered onto the blinds and all those surfaces and the ceiling and the wall. 6 blows of attack. But blunt force trauma is not an efficient way to end someone's life, right? You can immobilize someone. Maybe they'll die eventually. It is not an efficient way to quickly end someone's life. And so I'd suggest to you that the rest of the evidence in this case is certainly consistent with someone then changing weapons. And one of the things we know is that at least the handle of the object that was the blunt force trauma instrument, right? Whether it's a bat or an axe with a wooden handle, whatever, some kind of hammer with a wooden handle, whatever that first blunt force trauma object is. We know that there's such magnitude of blows, such force, whatever, that wood shatters. You know that the blows being administered to Rosalio Gutierrez eventually shatter that wood, because there's a shard of that wood that you see that has hair of Rosalio Gutierrez on it and the blood of Rosalio Gutierrez on it. Literally something that certainly seems like impacted his head, right? And there are other shards of wood found at other locations, right? On the couch, there's a couple of shards of wood. So we know that particular weapon got busted. And so some new weapon likely was employed. And I'd suggest to you a knife or a sharp object makes perfect sense. There's arterial spray, which is something that happens if you puncture an artery, which a sharp object will efficiently do for you and cause a spray, not the same blunt force trauma splashes and spatters and stains, but a different one. And often if you stab someone in their vital organs, because it's close to them, and if they're down and not fighting anymore, all you will have is blood flow and the drips and draining of their life out of their body. And so there would be no other and distinct evidence of this murder when you turn to the knife. And when you finish Rosalio Gutierrez, because he no longer in any way, shape, or form is able to fend off any blows. You have to hurry. People have already heard a little bit of a ruckus. You have to hurry. You have to finish him. And so you finish him and maybe get a little arterial spray, some blood drips. Your plan, the defendant's plan, was to make it look like he disappeared. And so he was going to stage this in a way that made it look like maybe this is a disappearance. And eventually people would figure that out, but that would buy some time, right? It's a Sunday night. This guy might be working in the morning. People might be coming over to his house first thing in the morning. How am I buying time would be your first plan. And so you are trying to create a plan. The defendant, the planner, is saying, I am going to try to stage this. But there's just so much blood, folks. And he's got to hurry. So he grabs up the wood pieces he can grab, but he misses one or two, right? He straightens up a couple of pieces of furniture that either fell over or got, repositioned as Rosalio Gutierrez is staggering, or maybe even, trying somehow to fend some blows off. Those moments of quick staging occur. You had an idea already, and so you follow through on taking his credit cards and his phone. You don't want to leave with those. You are afraid that those leaving might give some clue to where you've gone next, right? But if you hide them in the freezer, the battery will die quick, and there's a high likelihood that at least for a period of time, if somebody doesn't have their phone present, if somebody doesn't have their credit cards present, maybe they just left, right? So your half attempt to stage a disappearance, the defendant still chose to follow through on. Of course, the problem is there's just so much blood. And this staged disappearance will not allow you to leave that area rug, which is so saturated with blood, that some of that blood, before it was moved, has already spilled off into a larger pool that remains on the side of where that rug was. But what do? You take his glasses, because if a guy disappears, of course he takes his glasses. You take his boots, right, a pair of his shoes. You take some footwear, because of course if somebody disappears, they took that. So you take some basics to make sure you've staged it, but you got to take the rug. And you've brought supplies to be ready for this, right? You have made sure that you're going to minimize any kind of problems you'll have in your van and all that, but you didn't bargain for that much blood on the rug. And so you've figured out how you're going to transport him over. I don't know if you're using a tool or if you're just lifting him yourself. Whatever way you are moving that body that you've planned for, the body of Rosalio Gutierrez, wrapped in a rug, utilizing the duct tape and the rope that you brought, that your own daughter said was down in your basement when she left on this very same weekend. Using those supplies, you are leaving. But when you take this unwieldy, dead man, when you take him and you place him in the very back of your van, Rosalio Gutierrez and his DNA splash up. When you take him and you set him down, there's the tiniest of splashes. It's on the passenger side, halfway up that console. There's the tiniest speck of a splash that falls off as you set Rosalio Gutierrez's body down. It's almost imperceptible, but it's there, and it's in exactly the same location as the cutout carpet as that body was stored. And in the end, it reveals much of what a jury needs to know. So, while Rosalio Gutierrez is still wet with blood, while that carpet is still wet with blood, before it dries, when it would still be wet enough to splash because it's been seconds or a very few minutes since Rosalio Gutierrez shed that blood, that's when that speck of blood tumbles to that location in your van. And because you planned it, you do exactly what we would expect you to do, right? You wore footwear, maybe the steel-toed boots that you borrowed from your grandpa working at the tree farm just a day before. Maybe you wore those. You took them off. You put on some other footwear. You, of course, have now taken off your gloves. You've taken off that outer garment, the same that same plaid sort of very light sort of outer garment that both your daughter and Sadie say was the last thing they saw you wearing in the late afternoon on the very same day that Rosalio goes missing. So just that they saw you wearing about 4 hours before, 4.5 hours before Rosalio's death. You take those items off, and of course you package them up. This is your plan. You're not going to operate your vehicles with those things still on you. You've planned this, just like you left your phone at home. And so an investigation that is hoping that you were not a planner, an investigation that was expecting that you were not prepared for those type of basic things, is never going to detect you in that situation. Right? Only things that are going to detect you are the things you could not have planned for, things you could not have intended. Now, you get home right away, okay? And I'm going to talk about the timing in a few minutes here and how absolutely impossible it would be for the timing to fit together this well and you'd be an innocent man. But you're home by 11:19 p.m. You've been radio silent. You've been off the grid for more than, for about almost 4 hours. Now you're on the phone. You're constantly on the phone from 11:19 to about 1 a.m. And so you are establishing your credibility and your bona fide that I've been here. Okay? Just like your plan was. You got back home almost immediately so that you could be sure that if anybody ever looked at you, that you were accounted for in a way that was helpful to you. But then after 1 o'clock, you're again off the grid for about 3 hours. Okay, now it's the middle of the night, so a lot of people are doing nothing during that period of time, right? But from 1 to 4, you're off the grid, and that gives you plenty of time to dispose of Rosalio Gutierrez's body in the planned location and to do some of the cleanup. Now, maybe you're in a dark location. Maybe you can't do all the cleanup you wanted. Maybe you find that when you start to do the cleanup, that some of the blood has actually saturated through whatever you thought was going to contain it, and it's actually seeped into part of the carpeting and matting in the back of your van. Okay? So maybe you are finding that Plan A is not going to be exactly workable. And so maybe you didn't have the tools for that bit of your preparation now not working perfectly. And so by 4 a.m., you are again trying to figure out where you can get cleaning materials early. And so you end up at Walmart and you buy more rubber gloves and more garbage bags and cleaning supplies, and you go to a location for 3 hours where it's people with family connections to you. It's a location you know no one else is going to be at, and you can finish your cleanup, again bagging all the items, again being meticulous about making sure that you don't leave any evidence, and of course at your own house over the next couple of days you must run that fire pit and start to destroy some of the rest of the evidence. Because even when you do the cleanup, right, even when you do the cleanup, you are concerned that maybe the personal clothing that you are wearing will somehow be able to be tied to you, right? If somebody finds some of this stuff in a dumpster or buried somewhere or somewhere controlled, you can't leave your clothes, which is certainly going to have your DNA on it, right? Your pants, your socks, the boots you were wearing. You've got to get rid of those in a way that is DNA proof. And you know how you do that? You do that with fire. You burn those things so that no DNA will ever exist. Okay, so that's why the burning pit is going on in the rainstorm for a couple of days. Because you're burning steel-toed boots. And we find at the very top of that burn pile steel toes and shoelaces, right? You burn your underwear, and we find a fragment of your underwear. You burn your jeans, and we find some buttons. And in fact, you might even burn 2 pairs of jeans, right? Because you might have changed jeans once from the time you committed the offense and then when you did the cleaning of the van in that second situation. So you might even You might even need to burn multiple pairs of jeans. And you burn socks, right? The ones you wore when you wore those boots. And so at the very top of your fire pit, there's bleach, and there's those kind of clothes consistent with that set of garments that you could have. Okay? Those things are found in the fire pit. I want to talk about some of the major witnesses in this case for just a second, because I think that they're I want to have you hear me talk about sort of how I think they responded on the stand and where they sit in terms of your ability to adopt what they have said. So I want to speak first about Sadie Beecham, okay, who was, I think in every way you heard her, right, on the stand, confronted on cross-examination, in her texts, on the phone when you heard recordings of her. She is part scared, part at wit's end. She is frustrated. There are times she is trying to appease and make nice with the defendant. There are times she's trying to just manage a conversation, just trying to say anything she can to end the endless string of texts or end the hours-long phone calls. And in the meantime, there are family issues, right? There are a couple things happening in their lives which do not allow her to cut off all contact with the defendant. Do not allow her to have some rule that says, you know, when I tell you you're not welcome in my house, that means you can never, ever be over here because I need help sometimes with my daughter. And so she is a woman just trying to have something of her own. She's trying to have some relationship in her life that is not about the defendant. And he deals with that with such obsession, with such hostility, with such fury, that she tries every strategy that anyone has ever come up with to try to deal with that. And that's exactly how you folks on the jury would expect someone who is being stalked and who is being dealt with in that way day after day to behave. Sometimes she wants to curse at him. Sometimes she wants to try to say nice things to see if that'll work. Sometimes she wants him out of her house. Sometimes she needs him to help on something. This is real, but it doesn't mean that it's not overwhelming, oppressive, and something that she is truly scared of. I want to talk about the daughter in this case, who now is 14 years old, right? So you heard a 14-year-old who was, I think I'm going to call her sassy, who was courageous, who was absolutely adamant. Ladies and gentlemen of the jury, absolutely adamant about the things she told you, about things like that the back of that van was not cut out when I last saw the back of that van on the weekend of the 16th and 17th of May. Like that my father made me his spy, that he stole things from the car. All of those things she said. She was adamant about those things. When challenged by the defense, she gave extra details that she remembered, and she, in tone and in bravery, made it absolutely clear to you as a jury that she is her own person and that she knows what she is talking about. Now, is she perfect? Did she say exactly the same thing in exactly the same order as she did back in 2020? That would be impossible to do. As a 12-year-old and now 14, of course, some time has passed, right? But as to everything that truly matters, you will see a couple of things that were inconsistent, and they will not be things that for you truly matter. Was she coached? Was any of what she did something where an adult has ordered her or dominated her to provide that information? I would suggest to you she's the exact opposite of the personality of some 14-year-old who can be coached in terms of what she will say. Exact opposite. I want to talk about Marquand Washington, the inmate who came and told you what the defendant told him when they had a cell together for about a little more than 5 weeks. And I want to contrast him with Mr. McAtee, the inmate that the defense called to talk about Marquand Washington. And I think it's constructive to talk about them together for a second, to talk about what matters in terms of your thinking about and assessing that information. So Marquand Washington knew the defendant's home was in Mequon. He knew it was a home in poor condition in a rich area. That appears to be the case. He knew details about the defendant's family that have been unchallenged in this case. He knew about circumstances of the case which are sort of unimportant circumstances, but they're details that might lead you to understand that he has insider information. So what do I mean? Well, he says in the raid that the police found a lot of cash. The police found $47,000 plus, but only a little bit of weed. Okay? And sure enough, that is a summary that would be accurate in some, from some perspectives about what happened in a collateral part of the case. So these are the kind of details. He knew what his job was. He knew he had worked for, in construction and in cable, laying cable. So these are things that Marquand Washington knew about the background of the defendant. So he knew some personal facts. And then he talked about what, of course, he told him about the offense, and he told him this was a private conversation. No word was ever said to me where another person was ever present. He only told me a few of the facts. He did not outline everything that happened in the case. That he also told the defendant all sorts of details about his case. You heard Marquand Washington say he's never cooperated before. So this is the first time he's ever done this. And again, that is unchallenged in this case, that he has not been a person who from a jail has ever informed on an individual before. There's absolutely no evidence of any other cooperation along those lines, where in the context of hearing something in a jail, he decided to do something with it. He also told you that if he lies, if he's caught in a lie in this case, that the agreement that he currently has will be eliminated, will be destroyed. So really, he is at huge risk if Marquand Washington decides to say anything that is false in this case. He's at huge risk to have everything that he's hoping for in a federal agreement be destroyed. So here's the contrast with Mr. McAtee. And I think it's so helpful that you got a chance to see Mr. McAtee, because now you get a chance to evaluate what a jailhouse sort of operator looks like in contrast to what Mr. Washington gave you and showed you. Okay? So they're similar. They both have a federal case, right? So they have surface similarity. Mr. McAtee has 11 priors. But Mr. McAtee has 2 recent in time situations where he has fraudulently caused pretend legal mail, so pretend documents, to be sent into the jail where he was fraudulently involved in this under attorneys' names. So there would be these innocent human beings on the planet who would be supposedly the person who sent these documents into the jail, and they would have drugs in them. So theoretically, 2 other human beings, in this case lawyers, right, would be individuals who would be, of course, under high suspicion, right, of having caused drugs to come into the jail. And what the defendant, what Mr. McAtee admitted to you is, yes, I was involved in those plans. In the second one, after he's caught the first time, he actually goes to the legal computer in the jail and completely forges a legal envelope and the legal mail. In both cases, he uses cellmates, okay, people he's been incarcerated with, as part of his fraud. So you know about Mr. McAtee that in the jail setting, he is a documented forger and person who's trying to fraudulently do things, that he's willing to risk totally innocent parties in that fraud, and that he forms alliances with fellow inmates to do things that are not proper in these circumstances. Does not sound like somebody who could be relied upon. What else do we know about Mr. McAtee? Well, he was asked, he claimed that he had a deal that he'd been offered by the state. When surprise was expressed about that, as I recall it, the judge asked his attorney, who was in the gallery, and his attorney said, no, there's no deal. So Mr. McAtee was contradicted by his own lawyer about the circumstances of his coming to testify in front of you while he was here. I don't know how more clear it can be that Mr. McAtee cannot be relied on by you for any information. And then finally, Mr. McAtee, and I tried to be very careful when I did this under cross-examination. I asked Mr. McAtee, so tell me where this man was who was yelling to you or telling you in above a conversational voice, essentially giving you a tutorial on how to be a snitch in the jail. And he said, I was in the upper tier, as was this other gentleman, okay, this person he's talking to. We can't see each other because there's mesh there. The cell fronts are obscured, but we're talking and he's across from me, upstairs. Well, when we looked into it, Marquand Washington was never upstairs. So, again, the most basic reported fact by Mr. McAtee is false. Whoever he had a conversation with across from him is not Marquand Washington. If that conversation ever took place, he's got the wrong guy based on where he told you this person was located. Because Marquand Washington moved in a couple of different places, but he was always, there was never a time he was in that upper tier. Okay? McAtee is just plain wrong about the basic detail that he tried to give you. In fact, you saw the pictures. They're on the complete opposite ends for all but 6 hours of the time they're together. And even then, they're not on the same tier. So literally, you'd have to have a situation where guys who are all the way across from each other, where Marquand Washington is willing in the security part of the jail. Remember, these are people who've already misbehaved in the jail. Is that the environment where you think it's at all reasonable to believe that Marquand Washington, a guy as careful as he sounded in this courtroom, is going to scream out instructions on how to get yourself out of a case, how to be a snitch, with other inmates obviously able to hear that same thing? When McAtee himself told you federal inmates who snitch are in danger. So why would Marquand Washington advertise that? And remember, Marquand Washington had never cooperated at the time this was talked about. So you'd have to believe he was literally giving advice, even though they got the location wrong. He was literally giving advice on something he had never done that would put him in mortal danger. And your authority on that is a guy who's fraudulently sent legal mail to get drugs 2 times using other inmates. Okay, so I also want to talk about the 3 crime lab analysts for just a second, right? So you have Lisa Treffinger, Ron Watucky, and Julie Avila. You have more than 70 years' experience at the State Crime Lab. All 3 of them tell you and this is undisputed, there's no competing evidence in this case, all three of them tell you that stain in that van, okay, it's A1 in their lab stuff, right? A1, that stain in the van of the defendants, is blood. Every one of them offered you the opinion it's blood. 70 years of experience, okay? People who go to crime scenes as their job every day over many of the years of their careers. Okay? 3 different experts tell you it's blood. 2 of them also tell you, so now you also know, again, undisputed, it's the DNA of Rosalio Gutierrez. So it's blood, and it's undisputed evidence in this case that that is the DNA of Rosalio Gutierrez. Lisa Treffinger, an expert on this field, tells you that she did the testing. Ronald Watucky, who reviewed those findings, told you about his conclusions about this case. And then 2 of these 3 experts are asked, and so now this is Ron Watucky and Julie Avila. What else can you tell us about this speck, this red-brownish speck in the van? And those 2 individuals, Ronald Watucky, who's been working at the state crime lab since before they started doing DNA, and Julie Avila, who has 22 years there, said, we've seen lots of blood. Not only does it look like blood, but it looks like it is splashed on there. In other words, it is not transferred blood. Again, this is their expert opinion. It hasn't been smudged on there or wiped on there. It's not, in other words, something someone planted there. It's splashed on. When that blood was still wet, it's splashed on. 3 crime lab analysts give you such important evidence in this case. Okay, so we talked about how this evidence is organized. We've talked about what the evidence is. The burden of proof is on the state in each and every aspect of this case. Okay, so in no way let any argument I have said in any way, shape, or form indicate to you that there's any other burden of proof but the state of Wisconsin, each and every element. You're allowed to consider the evidence and organize the evidence in any way you want, right? You can think about it and organize it as a group and in your own minds in any way you want. And I'm going to ask you to think about the evidence in this way as one of the ways you do consider it. Could all of the things I'm now going to go through, could all of them be true for an innocent man who is falsely accused? Could an innocent person falsely accused have all of the things I'm about to outline to you happen to them? Is that in any way reasonable, is my question to you, okay? So, Rosalio Gutierrez is murdered on May 17th, 2020. His body's found on May 19th, 2020, okay? If the defendant is an innocent man and falsely accused, this should have 0 effect on him, right? He lives in Mequon. That is an hour's drive away. There's absolutely no way the death of a person in Kenosha should impact him in any way, innocent and falsely accused. Okay? Now, here's where it starts to get more and more unlucky for him, more and more unreasonable for him to not be the person who committed this offense, right? Because it turns out that this person who should be a random person in the life of the defendant is actually the first man that Sadie has dated since she ended her long-time relationship with you. Okay? So now we have, it's not just a random city, it is the guy who Sadie has been Sadie's first kind of real, some kind of relationship since she broke it off with you. Okay, again, if you're an innocent guy, you're falsely accused, you have your own girlfriend, you're not, you've said you're not jealous in any way, this really shouldn't impact you, right? This is a guy she's dating, but so what? It should have 0 reason to cause you any concern or be a problem, a situation that's a problem for you. However, here's a problem for you. Here's where it starts to be so unfortunate if you're an innocent man and falsely accused, right? Because even though you have a girlfriend, even though you are not a jealous guy about this new relationship Sadie has, when the police start to do digging, They find all sorts of documentary evidence that you are extremely jealous. There are, for instance, on your own devices, recordings of you talking about how jealous you are, that the state played for you in this case. There are legions of emails that we showed you and texts that show how jealous you are of her relationship. And so, unfortunately for you, there is a body of evidence that documents that even though you have a girlfriend, you are very extensively jealous in obsessive ways about what happens in Sadie Beecham's love life. And so here's how unlucky you are. Those kind of obsessive acts of jealousy that you have also begin to show that you don't know any limits. Here's how unlucky you are if you're falsely accused here, right? Because on March 4th, you go into Sadie Beecham's home where her babysitter finds you looming over her, wakes her up before 4 a.m. in the morning. You are screaming about how Sadie Beecham is a whore, and you are accusing the babysitter of being a whore as well in your fury. And it's all about jealousy because Sadie Beecham, who is broken up with you, had the audacity to go on a vacation and not let you know, and she surely is cheating on you. It's got to be that she is cheating on you. And you go wake up your 12-year-old daughter, and by the way, it's a school day that next day, and your 4-year-olds. You go and wake them all up, and you, knowing no limits, make them a breakfast, a 4 a.m. breakfast on a school day. You don't know any limits. And by March 4th, we are already getting a flavor for how you behave when Sadie Beecham refuses to be under your thumb. So it's unlucky that you would have done that just a couple of months before, and somehow Rosalio Gutierrez is murdered on May 17th. But here's how much more unlucky you get. Because that date of May 17th turns out to have a bunch of significance if the person involved in the murder is really focused on Sadie Beecham's love life, right? Because May 17th, the date of the murder, is one day before Sadie Beecham meets Rosalio's kids for the first time. And if you're monitoring Sadie Beecham, if your antenna towards Sadie Beecham is obsessive and controlling, and anything she does hits your antenna like a rocket ship, right? Then when she meets his kids, you have a whole nother degree of concern and fury. And in fact, the day Rosalio Gutierrez is murdered, Sadie Beecham texts Rosalio and says to him in a text, "I would like to take our relationship further." These are the words that the defendant cannot allow. He cannot tolerate these words. He will not let this happen. Is it an accident or just horrible random fortune that Rosalio Gutierrez is murdered at the same time that her obsessive ex would be learning and beginning to find out that all the steps and signs look like she is moving on? Is that an accident? You are horribly unfortunate and as an innocent, falsely accused man if that's the case. And so here's how bad your fortune is if you're innocent and falsely accused. Sadie Beecham, who remains at the scene on the 19th when this bloody scene is discovered, reveals to law enforcement, hey, I think my ex has been monitoring me in a variety of ways out of jealousy. And this should be easily cleared up. Okay? So this should be an opportunity for an innocent, falsely accused man, right? Because The defendant has already told Sadie in a variety of communications, and Sadie herself told you, he's already told me none of these things are true, right? On the 24th, I have a very good excuse for why I was at your house and peeped in, although some of it involves a premonition. On May 8th, I accidentally must have dropped a phone in your car. I never did that on purpose. I'm not monitoring you. And then on the 13th, it's just pure accident that I texted something to you that's the same thing that Rosalio said. I was never anywhere near you. Okay? So, assuming this is true and you're not an obsessive ex who's been doing all these very disturbing things, this should be able to be cleared up. It should be able to be cleared up. Here's how unlucky you are if you're an innocent, falsely accused guy. All of the electronics in this case back up Sadie Beecham. Okay? They back him up. She says, we were videotaped. That's what I've been told. Sure enough, there's video. She says, I believe he was tracking me on May 8th. I don't believe him that he dropped it accidentally. What does his computer show? That he was actually tracking her. Not only that, but the places that he tracked her, he took screenshots of those trackings, okay, of that phone, and he put them in the Rosalio Gutierrez file on his computer. So he's lying to her. Okay, he's lying to her about that. And then on May 13th, his phone, his own electronics, puts him in Kenosha at the exact time that that text is made to her that repeats the words Rosalio just said to her. So every time the electronics finds, rather than clearing him, that he's lying. And that those obsessive, boundary-breaking moments are all true. Okay, so here's another horrible piece of luck if you're an innocent guy and falsely accused. After you found out Sadie was seeing someone, you purchased 2 trackers, okay, to track vehicles with no explanation for that is in the record, right? That we don't know of any reason, but it certainly is coincidental timing. And you know, here's one thing that would be lucky for you again. Here's an opportunity you could clear yourself, right? If those 2 trackers could be found, surely they would show that they haven't been mounted on Rosalio's vehicle, they haven't been used to follow him or make sure that you know he's home at certain times or any of that. But one of those 2 trackers can't be found at any of the search warrants. We found 1 but not 2. We ordered 2. We know 2 were delivered based on the electronic information. 1 is missing. What horrible luck if that tracker would have again been able to clear you. Okay, here's horrible luck. Marquand Washington, who you roomed with for 5 weeks, only time he's ever cooperated, says all the things he says, including that you ended up stabbing this man in the end, that you used garbage bags, that you'll never be found, that he'll never be found, and that he suggested the way to kill someone is to surveil them and keep tabs on them and use the devices you can buy, like trackers on Amazon. Here's horrible luck. You yourself bought trackers on Amazon. You yourself have been documented in all the ways we just talked about on each of those days as being involved in surveillance of the victim. So all of the ways you said would be the right way to prep to do a murder, to do a mission of murder, are actually confirmed by your own devices. That's really bad luck. It's horrible luck if you've been falsely accused. Okay, so, you know, here's a moment where you'd think that, that you've been monitoring this guy. You do admit to the police that on April 24th you did peek in the window, but you took your 11-year-old to witness it. Your 11-year-old who was about to turn 12. You took your daughter to witness that. You used her as a tool, as your fellow spy in there. And so, again, you're unlucky because a jury hearing that will know that you don't have any of the limits that they would expect for a person who was innocent and falsely accused. Now, here's another one, right? You're accused by Sadie as part of these accusations of taken items from Rosalio's truck, his registration and a letter to a person named, or from a person named TJ. The daughter also confirms those things. But you didn't do this because you're not jealous and you are not controlling, and of course you do know limits, and you're just being falsely accused. So again, here's a moment where if you're an innocent falsely accused guy, we're going to be able to clear things up, right? Here's a moment where we're going to be able to show, okay, we've now looked at what you did, what you're saying, that you didn't do these things, and we're able to verify. But in fact, just the opposite is true, isn't it? Because what we find in his electronics are, we find that not only right after you would have returned from Sadie's place on April 24th, so in the early morning hours of April 25th, you're already doing searches of Rosalio's Colorado plate and the name of Rosalio's stepdad, a name on your registration document, okay, which was in the truck. So you are searching for a name that you shouldn't have unless you have a document from his truck. And then, again on a device, we find a snippet of that same registration document which has the stepdad's name on it, and in the defendant's own handwriting, he has the handwritten address of Rosalio Gutierrez. So again, we have a portion of the document you stole from that truck on your electronics. And so we know you're not telling the truth again. And again, we know you're not telling the truth, and you know no limits, and you have obsessive jealousy, and it's focused on Rosalio Gutierrez. Okay, so, again, you claim it was an accidental plant of the phone on May 8th. Again, this should be able to be cleared up, but I told you it's on his computer. So again, that shows you're lying, and again, horrible luck if you're an innocent guy falsely accused. Here's horrible luck. You're an innocent man, right? You're not jealous. None of this stuff is true. It's just a horrible set of coincidences and circumstances. But you have a file on your computer that is named Rosalio Gutierrez. You had to write that name on there. And in it is not only a picture of a tracker that you've included in that file, but all sorts of pictures of Rosalio Gutierrez and his kids. On the defendant's computer are pictures of Rosalio Gutierrez and his kids. We passed those through you guys as a jury. Horrible luck if you are not responsible for his death. Horrible luck that you were bothering to put things like pictures of his kids in your computer, that you had to take off of some internet source, right? Facebook or something. You had to screenshot each one of them. You made a choice each time that was important to you. It was important to store that. No limits on the defendant and his behavior. On May 13th, again, we should be able to clear you on May 13th. Sadie says, listen, he texted me the same thing that Rosalio just said when I was at his place. There's no reason that the defendant should be over at Rosalio's place when I am visiting him on May 13th. Well, your bad luck is that your phone puts you there. At the same time she says that text is being made, your text is the same words she claims are on there, and it sure looks to a jury like you are rehearsing, like this is a dry run for the murder you will commit 4 days later. So here's how your bad luck continues, right? Because there's a crescendo of activity that seems to be leading to a homicide, and it's bad luck that these are things all from you. May 14th, okay, 3 days before the homicide. Do you want me to stop by to meet Junior tonight? Not a little later, half hour later. So you're saying I can stop by and meet someone later? You're taunting Sadie. You're taunting her and thinking gloriously about what will happen when you meet him. Remember what your daughter told us? Remember what she said on the stand? Let me get to that. Let me make sure you guys hear that one more time. She says, my dad said something about showing him who the man was. That sounds like what you're up to on May 14th. May 16th, one day before the homicide, folks. One day before the homicide. You have the kids over when this text goes out. You're not a jealous guy, right? You're an innocent man falsely accused. And what you're bothering to text Sadie Beecham is, this is one day before the homicide. You race down to Kenosha every chance you get to lay down with some Down syndrome Mexican version of your father. That's how you choose to address her one day before the death of Rosalio Gutierrez. Awfully, horribly unlucky and inconvenient if you are an innocent man falsely accused. Here's where the bad luck gets profound. Here's where it becomes patently unreasonable for you to believe that the defendant is an innocent man falsely accused. Because on the murder, the evening of the murder, okay, around 10 p.m., the defendant's phone, at the exact time period necessary to commit this murder, is off the grid. In fact, all of his devices are off the grid from 7:30 to 11:19. What are the chances? What are the chances of the exact time period needed to drive to Kenosha, wait around, wait for Rosalio Gutierrez to get home at a little after 9, murder him at around 10, and then get yourself back to Mequon? How is it that that amount of time is the exact period of time you're off the grid? That would be the worst luck in human history if you were a person who was innocent and falsely accused. Here's the absurdity of any conclusion other than that the defendant is involved. Okay? Tell me how this portion of bad luck could even exist in the world. The defense put in some evidence about the phone changing position. You remember it went from up to the side? And the time period on that was 10:11 p.m. on May 17th. Okay? I'm going to suggest to you by far the most logical reason why that phone would change positions is it's been placed in the freezer. Right? That's why it's changed position. It's now being hidden in the freezer at 10:11 p.m. Okay? Well, we know from the defendant getting directions on May 13th. Remember you heard the recordings of those directions? That the directions that the defendant got on May 13th were just a minute or two over an hour. 10:11 p.m., the phone changes position and goes in the freezer. You got to take care of a few more things, right? You got to straighten up things, maybe pick up some wood. You've already moved the body. Now you're doing the last staging, right? Okay, I'm going to leave the wallet on the couch, but I'm going to put the credit cards on the phone. You're doing those last seconds of staging. So maybe you take a couple minutes to do that. You're home, back in Mequon, answering your phone at 11:19 p.m. An hour and 8 minutes from when that phone changed position. Can that be an accident? Is that just horrible luck? That one of the final acts, one of the things that makes sense to have be the final act of your staging, exactly times you to get you back to Mequon to use your phone as quickly as you can, so you're back, so you can start to get your alibi running and going? I would suggest to you the chances of that timing being true for an innocent, falsely accused man with all the rest of what I've said is astronomically impossible. It's impossible. What else? Well, remember, this is an evening. Here's how bad luck it is. Your girlfriend, Miss Remsburg, is expecting you. She is texting and calling you throughout the time you're off the grid, saying, hey, thought you were coming over. Here's what I was making. Here's the movie I was planning. Okay, I guess you're not coming. She gets madder and madder as these go on. Clearly does not know you're not arriving. In fact, she said that on the stand. So a night when she expected you, on the very night Rosalio Gutierrez is murdered, you're not in the place where you were expected. And you even when you do get in contact with her, you have a long call with her around midnight, you still don't go over there. You don't go over to make it up. If she's mad, you don't do any of those things because you need that time to dispose of that body and get rid of evidence. So horribly unlucky that that would happen. Okay, here's something unlucky. It's the 19th now of May. You're arrested, right? You have taken out on May 15th $50,000 from Wells Fargo Bank in 20s. So it's in cash. You still have a little more than $47,000 at your place. And so you're unlucky because a jury could reasonably guess that that's your cash money for if this murder somehow goes wrong. Right? You have an escape fund that is ready. You are ready before the 17th with a bunch of ready cash so that if you need to not use a credit card, not show ID, pay just like you paid at Walmart on the 18th, you have all the cash you need to be on the run for a good period of time. That's horribly unlucky if you're an innocent guy and falsely accused. Horrible unluck that you need to burn some clothes and it is heavy rains and you still are operating a fire pit. Do you remember that one of the witnesses in this case, who's a friend of the defendant, said, yeah, I went over there on the 18th, pouring rain, he is operating a fire pit even then. And so you have this fire going through the heavy rain. Here's how unlucky you are. The very top of the ashes, the top level of the ashes, have jeans button, Hanes sock, underwear, bleach bottle, and steel toes for boots with laces. That's at the top of the burn pile. This is what you have been burning most recently in terms of things they can see. And it all sounds like the type of things you might need to burn to cover up DNA. That's horribly unlucky. That you would be involved in a burn in heavy rainstorms for days, and at the top level are the very things that seem like you are trying to destroy DNA. Boy, you're unlucky that the back third of your carpet is cut out. You're horribly unlucky, and you're horribly unlucky that your 12-year-old daughter and now 14-year-old daughter reports that isn't how it looked when my brothers got out of the vehicle. I saw what my dad put in there. I saw what my dad had. And the carpet, in terms of bleach stains and the cutout, she was adamant with you folks on the jury that that back third was not cut out when she last saw that van on the weekend of May 16th and May 17th when she left. Her mom picked her up on May 17th in the afternoon. Remember, Ms. Remsburg also said that van cutout, we showed her a picture, she said that van cutout did not exist when I last saw the van as well. So 2 witnesses told you that that third of the van had not been cut out. So what horrible, horrible luck for the defendant if he is an innocent, falsely accused man that for some reason he cut out that carpet, it's in the exact place that that speck of blood of Rosalio Gutierrez is, and here he is with that carpet cut out. Now, again, if he cut it out recently, we probably would be able, you'd think, well, he could clear himself, right? Because we'd find that carpet somewhere on his property. But that carpet cutout is gone. Again, it's missing. And it could clear him, right? Just like Grandpa's boots could clear him. Just like the shirt might clear him. All these things that could clear him are missing from this case. That's because they would never clear him. That's the real answer. But what a horrible circumstance for a guy who is falsely accused. So, you think about the ultimate bad luck in this case. And I already talked about the DNA evidence, so I won't belabor it. I just want to say, what are the chances that in this exact square foot on the planet Earth, the exact square foot on the planet Earth, a man who's innocent and falsely accused would have the blood of the man who died on May 17th? How could that happen? What is the astronomical, unbelievable bad luck to have that in his van right under where carpet has suddenly been cut away, right, in the same van back as the bleach stains? How could that be? And your daughter, how could you be so unlucky that your daughter is also willing to testify that you were focused on this guy, that you were stealing from him, that you were spying on him in all sorts of different ways, that she was being asked to spy on him, and that every time she saw you, this is what you were obsessed with? Could you be an innocent and falsely accused man who has your daughter say all those things, including, I may just watch him or follow him to his house one time just for the fun of it? So I want to end this sort of idea that you can't be an innocent man falsely accused with this piece. Unchallenged evidence in this case is that two individuals, Mike Campbell and a buddy, go to the defendant's home before law enforcement is ready to come in and arrest and do a search. Mike Campbell, this is unchallenged evidence in the record here, says, I told the defendant, I thought at the time he was his brother, that's what he had told me, but I told the defendant, hey, we're looking for our buddy in Kenosha. He was dating your ex and he is missing. So now the defendant knows, okay? If he's an innocent and falsely accused guy, he knows, okay, people are concerned about a guy in Kenosha who's missing, and he is an ex of, he is dating my ex. And of course, he already has a computer file on this guy, etc. So, you know, there's no way the defendant doesn't put two and two together about who they might be speaking about. So now Kenosha law enforcement are now going to talk to the defendant, okay? He's been visited by people who told him, hey, our buddy from Kenosha is missing. He knows that it's Sadie's new boyfriend. Now police are speaking to him, okay? There's no way the defendant on the 19th of May does not understand what a big moment this is, okay? Here is his opportunity by telling the whole and total truth to clear himself, right? He will be able to clear this up. You just got to tell the truth. You just got to be honest about what the circumstances are so that we can clear this up. Because this is a big deal. This is no one playing around. Someone's missing. What does he choose to do at that moment? And you tell me if an innocent and falsely accused man would behave in this way. Okay? They ask him about what car he operates. You know what he says? The Audi. He goes with the Audi. They keep pressing him. Oh, yeah, okay, well, there's a van, but I hardly drive that. They press him some more. Everybody drives that. Well, you know from Remsburg that the defendant at this time period is using the minivan. You know from the Walmart video the defendant is using the minivan. So the defendant, for some reason, deliberately tries to avoid talking about the minivan. 2 days after the homicide, knowing Rosalio Gutierrez is missing, he doesn't want to talk about the minivan. He's trying to steer the detectives to the Audi. Why would you do that if you're an innocent man and falsely accused? They ask him about the different circumstances. They ask him about whether he placed a phone on May 8th. Rather than sharing that, you know what, I have monitored the phone on occasion, you know, there might be something on my computer, I've put it in Rosalio Gutierrez's file, he denied that on May 8th that he had done any placement of a phone. The electronics show that that's not true. He chose to lie to law enforcement about that incident relating about what Sadie and he had talked about. He said, I never videotaped on that April 24th incident where I peeked into Sadie's window with my daughter. Never videotaped. Well, why would you say that when we have that video on your devices? When you, the jury, got to see at least snippets or a glimpse of that video, what we have of that video. And so, again, he chooses to lie about that rather than saying, yes, here's all the things I did, but I never did the piece that I don't have anything to do with this person in any other way. He said, I've never seen this Rosalio other than the one time I saw him through the window. Well, we have the directions to Rosalio on May 13th on the defendant's devices. We have the text. We have the phone that shows he's at that residence at that time. He's asked about, does he know who Sadie is dating? Okay, now this is an easy one. He's got a file in his computer that he has labeled Rosalio Gutierrez. He's looked up Rosalio Gutierrez's background in all sorts of ways, right? This ought to be a softball question. Here's what the defendant does. He says, yeah, you know, I think his name starts with a, last name starts with a G. He's called Junior. He might be a contractor. He acts like he doesn't even know this guy's name, which is completely false and is not what you do if you're an innocent man and falsely accused. And then he is asked, members of this jury, he's asked, where were you 2 nights ago? Not 2 weeks ago, not 2 months ago, 2 nights ago. Okay? And he says, I believe I was with my girlfriend. They press him a little more. Christine Remsburg. I believe I was at her house. Now, he hedges later, but he goes with a false alibi. He goes with a false alibi. And you know what? When they go to talk to Christine Remsburg, she also begins. She's been with him the last 2 days since. You heard her say that. She also goes with a false alibi when the cops first talk to her. And she doesn't change her mind about that until after her sister, who also testified, said, you know what, that did not happen. I remember my sister had been stood up and she was mad. And then when they went back to Christine Remsburg, she said, okay, you're right. I was mistaken about that information. You as a jury are supposed to believe that they both gave a false alibi about something that happened 2 days earlier, and they both gave the identical false alibi by accident? You're supposed to believe that's just another horrible coincidence for an innocent man falsely accused? So I'd suggest to you, if you lie about what car you use, when the car that transported the body is the one you are avoiding, when you lie about whether you are doing any activities regarding Sadie and Rosalio, when your electronics tell us you are, when you lie about where you were 2 days ago, because during the time period we care about, Rosalio was being murdered, those are the type of lies you don't tell if you know how serious it is and you are an innocent man falsely accused. These things could not all happen. Those 40-plus things I just went through with you could not all happen to some unfortunate, innocent person who's falsely accused. The only reasonable conclusion, ladies and gentlemen, is that those things have occurred to one individual on this planet, the defendant, because he is guilty of the offenses before you. That's the only reasonable conclusion. No way all those things could happen, all in combination to an innocent man. You have 1,039 days of proof that Rosalio Gutierrez is murdered. His blood in that van is proof who murdered him. The electronics of the defendant himself demonstrate his obsession and his more and more concerning pattern, and that he knows no limits. And they tell you that he has a gap off the grid, which is exactly the amount of time that is necessary. And the defendant's lies to law enforcement confirm, because they are on such major matters, they confirm for you that this is not an innocent man falsely accused. And when you put all this evidence together, you will say to yourself, it was quite a plan, but it is not a plan that in the end can succeed, because it is betrayed by that speck of blood of Rosalio Gutierrez, it's betrayed by the electronics, and it's betrayed by the defendant's own lies. And you will find this defendant responsible, and you will hold him responsible despite this plan, that he tried everything he could to avoid responsibility. Thank you.
Okay, let's take a 10-minute break, and please don't talk about the case during the break. We're done on the 10 minutes.
Well, good morning, ladies and gentlemen. I just want to echo what Mr. Gravely said earlier, because we do share the sentiment that you've given us your time. You've taken time out of your lives. You've gone much further than we thought we were going to take in this case, and you've been incredibly patient. And it's a very important thing when we're talking about how jury trials function in our society and why they are so very important. And I know that all of you take your duty very seriously and have steadfastly taken an oath to do your duty properly. In our country, of course, it's part of our system that we don't leave it up to a prosecutorial agency or any one individual or even just law enforcement collectively to determine whether or not somebody is guilty of a charged offense. We bring in people from the community that have no bias, have no predisposed opinion about what the outcome should be, and we ask you to listen to testimony and examine documents because you are the finders of fact. What the judge did yesterday, before we took the break, was that he read jury instructions to you. Now, just so you know, you'll get a copy of those jury instructions, because I know it's kind of hard to listen for half an hour to all that legal stuff. But that's really basically the structure, the outline, and how the trial is supposed to work, giving you some guidance on what the law says. But there's nothing in those instructions that tells you what facts you are to find. And that's why you're here, is to focus on facts. You'll also notice, right before we started, the judge said no taking of notes during closing arguments. That's because what Mr. Gravely says and what I say is not evidence. The evidence part of this case has already happened. There's a theory that what the lawyers say in closing argument shouldn't even matter because we're not presenting facts to you. That's already happened. Now, I obviously take my obligation to represent Mr. Anderson fully, completely, and with the amount of attention that he deserves. So I am going to make some comments here. But I want to focus first on the fact that we are here to discuss what the evidence is. We just heard a 95-minute speech about what Mr. Gravely thinks the evidence shows. It was layer upon layer of conjecture. He used the words, maybe this happened, or I propose to you, or I suggest. And that's what argument is. It's really putting a spin on the facts. But the most important thing, and as you paid attention over the course of the past 3 weeks and a couple days, when you took notes and you paid attention, you are the finders of fact. Now, very soon, extremely soon, you're going to get to go back into that deliberation room and finally start this process of talking about the case. At the end of every day and during every break, the judge has told you, please don't talk about the case. And I know you've been dying to. As the developments have occurred and as the testimonies come in, it gives you an impression. Certain facts will stand out to you. Certain other things will catch your attention, and you wrote those down. Then that is your opportunity when you finally go into deliberations to compare notes and to debate what the facts of this case are. But we are urging you at the outset, let's focus on facts, not guesswork, not theories or anything else. Now, Mr. Gravely's right. He concluded with the fact that the burden of proof remains at this table at all times for each and every element of all the offenses charged. It never shifts to the defense. And some of his comments actually did talk about, why didn't the defendant do this? Why didn't the defendant do that? It's the state's obligation to present all of the evidence, both the burden of production and the burden of persuasion. In fact, it's been said, it was said at the beginning of this case, the defense doesn't need to call any witnesses. The defense doesn't need to say a word. And if the state does not carry its burden of proof, the only correct legal answer is not guilty. Right from the beginning, right from the outset of when this case was initially investigated and then the nearly 3 years that followed, this has been a process whereby the investigators and those prosecuting this case have had horse blinds on and are looking at one man only. And we've seen the process. That's why there was such careful examination, cross-examination, getting into the details of all of these events, including electronic evidence and everything else, all the surrounding circumstances, many, many witnesses in this case, because there was a fashioning of how this investigation was going to go. And I'll get into that a little bit later. Missed opportunities, things that are, frankly, shocking that they weren't looked into. Let's talk a little bit more about the overall background here. And what we do know from the evidence, this comes as no surprise, there's nothing disputed about this. Zachariah and Sadie were in a very long-term relationship that lasted many years. Together, they share 3 children. This was not a perfect relationship, not one made in heaven. And as you heard, there were ups, there were downs, there were a lot of things that are part of a normal relationship. And every relationship has its own dynamics. Over time, there had been periods of time when they were together, then they weren't, then they were doing other things, but they always remained part of each other's lives because, naturally, they shared children in common. One of the things they talk about often are making plans so that Zach could help Sadie, Sadie could help Zach in these situations where they each had other things to do and they wanted to see their children and remain part of their lives. Now, over the years, we get to a point where, as Sadie testified, she was starting to develop a relationship with Rosalio. And this, again, as you heard, was they met on a Facebook dating site. They had started kind of talking. They had met. But this was at the very early stages of a relationship. It had only gone for a few weeks by the time all this happened. And as time progressed, we come to what I have to agree appears to be a tragedy here. Nobody knows where Rosalio Gutierrez is. Nobody knows what happened to Rosalio Gutierrez. And when we hear his mother talk about how she misses him and his friends that have not heard from him, I understand that pain. I understand that anguish. There's a big question mark up in the air about what has happened here. But all of this evidence, if you want to even call it that, all the facts that have come in, as we analyze them piece by piece, we're going to see that this is not a case where the facts themselves, the evidence itself, establishes in any way that Mr. Anderson is guilty. I want to start off by talking about stalking, because that's actually more complicated than the other 2 charges, because as we know, there's 2 counts of stalking. One, alleging that Mr. Anderson was stalking Rosalio Gutierrez, and another count that he was stalking Sadie Beecham. There's a count of intentional homicide and hiding a corpse. Now, we all know what intentional homicide means. The instructions are very clear. It means the allegation is that there was an intentional killing of another person with the intent to kill him. And then hiding a corpse is very obvious as well. There has to be a corpse, and then there has to be an effort to remove it, hide it, to avoid prosecution, detection, etc. Fairly straightforward. Stalking is one of these weird laws where there's so many different ways that it can be shown. And you have to consider, as we have said, and we've talked about here, a pattern of conduct, things that connected together form an effort to basically cause somebody to have serious emotional distress. Not just annoyance, not just why are you bothering me, or can't you just please go away. It has to be serious emotional distress and or fear of injury or death. That's stalking, okay? It's not just problems in a relationship that we might normally expect to see, especially when there's a dispute going on about who's going to have custody of the kids. And you know, leading up to this, as Sadie talked about, there had been a discussion, an argument really, about what the status of the custody of the kids was going to be going forward. In fact, it had reached a head sometime shortly before this. And I know that Mr. Grayley would like you to believe that all of these efforts that Mr. Anderson was engaging in was in order to have this masterful, intricately laid out plan of murder. But another way, and a more reasonable way of looking at that, is this is a man who has 3 children with Sadie Beecham. He knows that they are not together at this point, and he knows that she is seeing other people, and they talked about it. And by the way, I heard, I think about 25 times Mr. Gravely say, if somebody's out there saying, I'm not jealous, I don't care, how can you believe that? Well, the testimony was, and you heard some of the recordings, that Mr. Anderson was honest about his feelings for Sadie, and he did admit that he had jealousy. He said that, yes, I admit it. And he was talking about that in the context of sending her flowers, telling her he loves her, and all of the other things that might happen when a long-term relationship is not on its highest level. Discussing where their future is in the context of their kids. So would it be surprising in that context when somebody goes on one of the easiest search sites that you can do, CCAP, the Wisconsin Circuit Court Access Program, when you figure out the mother of my children is going to be spending time with this person, my children eventually are going to end up having contact with this person, let's check him out. What's he all about? Does he have a criminal record? Is there anything going on? Is there anything that would cause concern? And it's an easy, takes 3 minutes to do that. And also just checking this person out because it's somebody who, as we heard, we're going to call her OA, you know her name, but OA is what we call her because she's a minor and because, of course, this is being broadcast everywhere. There had been problems going on with OA, with some problems, with parenting-type problems, parenting-type issues that they were having. There was some discussion about that. And Mr. Anderson was concerned about who she was hanging out with, what she was doing, what kind of influences were going on in her life. And this is all part of his effort to basically make sure that his daughter wasn't in a dangerous or bad situation by checking it out, by investigating, by looking. Now, probably one of the most important statements that we got from the text messaging that occurred here, when the state is saying that Mr. Anderson, when Zach was supposedly stalking Rosalio Gutierrez, did you hear any evidence that Zach ever had any direct communication with Rosalio ever? No. Did you hear any evidence that Rosalio was actually afraid? Not a shred. Did you hear any evidence that Rosalio was being intimidated, threatened in any way? Not at all. In fact, the statement that Rosalio uses in the context of what Sadie is reporting to him is, quote, I'm not worried. That in and of itself tells you that Zach is not guilty of stalking Rosalio Gutierrez. Likewise with Sadie, although she used the word fear on the stand, she did say that. Look at everything else that happened. This is someone who may very well have been annoyed by the fact that Zach was still trying to convey the fact that he still had feelings with her. He understood and said out loud, I know I have jealousy. I just want you to know I still love you. Again, all in the context of the children. But does it rise to the level of actual harassment, criminal harassment, is the question. There was a lot of bickering. There was an argumentative tone, antagonistic talk. They're swearing at each other. We heard that. There's name calling, none of which either of them are proud of, I'm sure, especially to have it played out here in court. But it was, for lack of a better term, a mutual process whereby they were both upset with each other about how the relationship had ended or is ending and issues about the kids. You have to ask yourself, how afraid was Sadie and Rosalio? If Rosalio's giving Sadie advice, you got to build a case, and he's talking about an expected upcoming custody battle with the kids. And by the way, some of the things I tell you, you better delete them from your phone because they're working together. And a lot of this, it's almost in a joking tone when they're dealing with Zach. Not afraid, but hey, maybe he needs a taste of his own medicine. Maybe give me his address. Let me know where he lives. These types of things. Not the kinds of statements that are made by people that are truly in fear. And that has to be shown, that there's legitimate and genuine fear. Now, we did talk about in the instructions, and I know that Mr. Gravely touched on this point as well, but it's not just you do something, someone says, I'm afraid, or I fear injury or death. We have to look at, in that context, not only would it cause a reasonable person to be in that state of fear, but it has to have actually resulted in that fear. So it's beyond just the hypothetical. There has to be proof beyond a reasonable doubt that that fear was actually caused, and that it's not just based on, I'm afraid of this guy in general. It's got to be specific as it relates to harassment, fear of injury, death, etc.
So, Judge, I'm going to object to the argument. It does not, the stalking statute does not require that you feel fear. There's a set of subsections. Fear is one of them.
I'll correct that then. Mr. Gravely's right. Fear is one of the things. It has a list of things that you can feel. Fear is one of them. Okay? Now, I just want to comment that we heard it in opening statements, and we heard some development of this concept through the questioning of witnesses. But this whole concept that there was this major step in the relationship between Rosalio and Sadie. This major step where she was meeting his kids, and how that shows how advanced the relationship has gone, how close they had become. And that may have been Sadie's understanding, but we did hear evidence that essentially Rosalio was talking to 3 different women in one day about various different things and not being forthcoming with any of them, 3 separate things going on. So it makes you wonder, how close was this actual relationship, and what was the design behind all the information that was being shared by both. Now, again, there's no evidence here that Zach Anderson threatened anyone with violence. Never said, I want to hurt that guy, I want to kill that guy, I want to do something bad to that guy. Words that were never spoken, never conveyed, and non-existent here. What we did hear is Rosalio talking about breaking his legs. We saw the text between Becky and Sadie where they talk about how something will be taken care of in the context of how to deal with Zach. But they're talking about how to deal with this, how to address it head on, how to take action. Not the kind of thing that someone does as a result of being stalked. But all of these were efforts that were aimed at him, things to do to him. Sadie felt that she just wanted Zach to stop saying, I love you. She wanted Zach to stop sending her flowers. I'm sure that's happened before, and I'm sure those people haven't been charged with stalking. Now, I want to talk a little bit more about OA, because Mr. Gravely made the argument that this is someone who was very clear. She may have been emotional. She may have been, I forget the word he used, but a little bit imprecise in some of the things that she said. But I think Mr. Gravely's acknowledging the fact that OA did give inconsistent statements. And this is important because at the beginning of the process, what OA talked about was the fact that she was not being honest with her mother or people that were asking her questions that had happened. She said at the outset, I wasn't being upfront. And what we can glean from that is that it's fair to say that OA didn't particularly like her mother dating Rosalio Gutierrez. We talked about the fact that she actually was the one that did the looking up on the computer of the location. And we talked about the fact that she was involved with looking at what's going on. And again, Mr. Gravely said that this is the opposite of someone who could be coached, yet his theory is that Zach coached her. It's an interesting part of that. There was also a stipulation that was read into the record about OA changing her story, giving inconsistent statements. You had your own opportunity to observe her on the stand, and I think it's fair to characterize this, that she went a bit rogue when that happened. Now, let's talk about the actual apartment where Rosalio was living. Mr. Gravely talks about how unlucky someone would have to be with all of this stuff, all these theories as to what had happened and the things that he suggests to you and the maybes and the what ifs. How unlucky it would be to be a target of that. It's also interesting to note that a killer would have to be the luckiest person on the planet to be able to do this crime and not leave any DNA behind at the scene. That is impossible. We also heard testimony from Detective Van Wee, which he was talking about the fact that there was the pooling of this blood on the carpet and that it had left this imprint. He used the words, the pooling was there in such a way that it had been there for, quote, a prolonged period of time. The theory that we just heard would involve somebody acting so quickly, so fast, with such precision and down to the second detail to barely squeak it into how this theory may have worked, that it wouldn't be possible for someone to have been lying there for a prolonged period of time bleeding. So that in and of itself is a huge chink in that theory. It doesn't fit the timeline. We also heard testimony, and I know Mr. Gravely commented that it's possible that somebody did hear a scream on the night around the time of May 17th, and it was never clearly established what night that was. In fact, an original statement had it a completely different night. And there was nobody that law enforcement were able to uncover dealing with any actual hearing or seeing anything unusual during the time period that happened. Also, as it relates to the timeline, we can see from the evidence that was gathered, including descriptions of the walkthrough video that happened, that it's logical that Mr. Gutierrez, when he's there, he has time to turn on the television, he has time to turn on his diffuser, he has time to have at least one, maybe another beer, cut up some limes, relax. And that time period isn't really accounted for in this down to the second theory that the state has about how it could have happened. We heard a lot of testimony about evidence that was gathered from a variety of different places, and I want to point out the places they looked and they found nothing that connects Zach to this offense. They looked in the sink traps. You remember that testimony about looking to see if there would be blood or any other kind of material in a variety of different places that would be collected in the sink trap. They looked in dumpsters all around the scene, dumpsters in other areas. They looked in these two fire pits. They looked everywhere inside and out of this apartment with Mr. Gutierrez. They did a full home search. They did a full search of the tree farm. There was the Zion, Illinois landfill. There was drone footage that was used. There were Crime Stopper tips. And none of this produced any evidence that is directly linked to Zach. Now, there are some things that Mr. Gravely gleaned from these, such as some buttons from some jeans, a bleach bottle that was partially burned, things like that. But in spite of looking at all these places where we would expect to find some DNA of somebody who was involved in some way in this, in all of that, it should have been found. Also, look at the relatively short time period we're talking about. If the murder did happen on May 17th, and if we're talking about 2 days later, this investigation really getting going, it's a very limited period of time. Police had the ability to investigate all of Zachariah Anderson's whereabouts. You couldn't have gone too far or done too much during that period of time. But the fact that they're focused on him and him alone and come up with nothing should tell you that they were looking at the wrong person. Very clearly. The evidence, the testimony was that if we look at the overall police investigation here, there were 5 locations that were searched. There were 8 warrants granted for property searches, 15 different law enforcement agencies, 100 officers involved, a couple of thousand man-hours, over 400 items of evidence processed, and 35 warrants for information that were granted. As we heard discussion from Detective Correa, this was the largest investigation he's ever been involved in. And I believe he said the largest one he's ever heard of. All of that effort was to find evidence that Zachariah Anderson is responsible for this murder. All of that was also directed towards finding a body, finding body parts, finding Rosalio. With all of that effort focused on one person, and the fact that they didn't find any of that should tell you they've got the wrong guy. They got the wrong person. Now, one thing Mr. Gravely said that was very interesting is that, again, when he's saying, I suggest to you, and maybe, and let's get in the mind of whoever this killer is. And it's someone who was meticulous, did a lot of planning, did a lot of research, did a lot of all these other things. And he suggests to you that there was a meticulously done process, including rearranging of things at the crime scene. Things moved around. And what he's not accounting for is where in the timeline that he suggests to you would there have been time to do that. Again, according to him, it really comes down to a matter of seconds where it's even remotely possible here. Now, I want to talk about the centerpiece of Mr. Gravely's case, and that is this dot, this minuscule dot that was located in the back area, passenger side of the van in question. And by the way, I just want to comment before I get there, and we'll come back to it later, some of the statements that involved who was driving, when they were driving, where they were driving, and things like that. But this was a work van. It's very clear. This is something that was not a vehicle that you'd take to go out to dinner at a fancy restaurant or pick up a date or do anything like that. This was what you'd throw junk in the back of when you're working on a demolition of a work site, putting stuff in there, building materials, garbage, stuff to haul away. And as was explained, it was common for Zach, as part of his demo jobs that he would do in construction work, he'd take all that stuff and then eventually burn it. And it was an ongoing thing. Burning was something that happened all the time at his house. Now, let's remember that in spite of what Mr. Gravely says, there was not evidence presented that, scientifically speaking, this little teeny tiny dot was in fact blood. What we do know is that there are scientific tests that are available to do that, but they weren't conducted in this case. There was an explanation for that because they didn't want to waste this tiny minuscule sample and have it entirely consumed to determine if it's blood. Now, let's think about science and what we want from scientific tests, things that use actual science, machines, measuring, use chemistry, all these other things that are involved in the process of producing a result that forensically, evidentiary-wise, we can say, yes, indeed, the science shows that that thing is blood. Okay? That would be a scientific test that was not conducted here. That would also result in a report that would say what they did, how they did it, the quality control measures that were used, the fact that machines would have been calibrated and everything else to produce a scientifically reliable result that we can say, yes, that is blood. What Mr. Gravely presented was something that wasn't in a scientific report and was based, if you paid close attention, on the color being this brownish reddish color. That was it. That was the sole basis for them saying that in their opinions that this was blood. Now, maybe it is, maybe it isn't, but this is a factor where when we rely upon science to do those things, we would like it to be done in such a way where it's not guesswork. There was evidence. One of the analysts said that it could be skin cells. But if we're talking about scenarios here, and remember, outside of Rosalio's patio door, we talked about how there were so many cigarettes out there. And these were cigarettes that weren't tested for DNA, but both sides talked about how this is an area where a person or persons were smoking. and leaving their butts right there. And yes, we talked about the fact that this didn't appear to be a smudge of whatever it was. It appeared to be an impact, something that was expelled, something that was traveling through the air. And that was based merely on the shape of it. Now, someone who smokes can end up having phlegm, stuff that they spit out when they're coughing that may not be, clear, could be brown in color. There's other reasons why something could be a reddish brownish color and not be blood. We also heard, with all those officers that I just talked about and all the processing of this crime scene, so many officers involved with collecting, preserving, transferring, transporting all of this data, all of this evidence. And it's got to be odd and questionable that there is one teeny tiny speck in this van that the state is saying means that there was a murder committed by Zach. Because wouldn't you expect to see much more throughout that van? All the other places that they said this might be blood, and it wasn't. In fact, there was no test that showed anything in that van was blood. There was no test that was done. Now, it's also important to note that the DNA test here actually was based on, we heard testimony about this, familial DNA. What that means is that it wasn't from a known sample that was a direct match of that person, but somebody that shares common genetics, and that's how that process occurs. Now, the significance of this is that we must remember that Rosalio was talking to Sadie about wanting to break into Zach's van. Wanted to know his address. He wanted to give him a taste of his own medicine. If Zach had broken into his car, he wanted to break into his.
Objection. That was absolutely never testified to.
That's
Never
it.
said anything about breaking into his van.
Very heard the evidence. I'm not myself allowed to comment on evidence. If the statement is not supported in the evidence, you must disregard it.
Right.
Thank you.
And much like Mr. Gravely took liberties with his spin on things, I'm talking about a logical inference from things that were said. And by the way, let me point out, the evidence in this case, a lot of evidence has been admitted, meaning that it's there for your review. You can wish to examine, read, look at anything that's part of this case. And I know we've just spent over 3 weeks doing this. And that is something that you absolutely have access to. The way we normally do it is we wait for you to ask, to see something. But please know that you have the ability to do that. And that if you want to take a closer look or a second look at something that is in evidence, you should feel free to ask for that. Now I do want to talk about how we've heard so much testimony about this violent crime scene, blood everywhere, a violent attack. These are all exhibits that were offered and received into evidence. This is Defense Exhibit 340. These are the photographs of Zachariah Anderson's hands right after he was arrested. There was a talk about a little tiny scratch, hardly even, not really even visible in these pictures. A guy that does construction work. Here's a close-up, and you can see for yourself. These do not look like the hands of a man that just committed a violent attack on somebody else 2 days before. Someone that would have used a knife and some other blunt force instrument. Defense Exhibit D342. Again, close-ups of Zachariah Anderson's hands. Nothing of note. Defense Exhibit 343. Right here, we can see what appears to be an old healing scratch, much like might have happened when you were doing construction work, but nothing along the magnitude of what Mr. Gravely suggests would have happened here. Number 3, defense 344, now a picture of Mr. Anderson's left hand. Again, pictures that don't match with what the state is theorizing here. D345, another picture of the other side of his hands. D346, the other side of his hands. D347, again, close-ups. D348. Now, interestingly, we didn't hear any evidence of any attempts to collect any DNA from underneath Mr. Anderson's fingernails or to process any of that information in any way. And I noticed that Mr. Gravely didn't make too much of a big deal about the whole Walmart scenario, because in his opening statement he did talk about the fact that in his view the evidence would show that Zach parked someplace very far away, and it's unreasonable that someone would be so far away from the entrance when it's raining. Well, we showed the video. The video is actually shown, and he parks right next to another white car, and there's other vehicles in the area. So the theory that he's somehow trying to hide the contents that's in his van is not supported by the evidence. We also hear a lot made of the fact that he buys gloves and Clorox wipes right when COVID is going on, and those are things that everyone was buying then. And by the way, what is the logic behind cleaning up blood, messy blood from yourself and everything else with wipes, with bleach wipes? And that doesn't make a whole lot of sense. Now, the fact that Mr. Anderson was looking for a store that was open early, again, this is during COVID. This is when he had to go out to a job site, which he did go to, and needed supplies and things. So he did a search to see who was open. And he went to Walmart, where we know he shops a lot. He shops there often. His clothes are pretty much all Walmart clothes, which, by the way, when he went there, he didn't buy any new clothes to replace any old ones. He's wearing these flip-flops that his daughter said he wears all the time, everywhere, constantly. Now, I know Mr. Gravely said that there's this issue about these grandpa's boots. And there was a picture of boots, same type of boots, that were found when they looked at the tree farm. So to suggest that there's a missing pair of boots isn't borne out by the evidence. Also, you'd have to ask that if someone's going to use a bunch of garbage bags to dispose of a body, why on earth would you buy 13-gallon, what typically kitchen-sized bags to accomplish that? That makes no sense. Now, we heard testimony from the work being done at that Cedar Grove home and the woman that owns that place. She talked about how there was lathe removal going on, and guess what? When they go to look at Mr. Anderson's place, there's a bunch of lathe and other building materials that completely matches that description of events, that he was doing a demo project. Significantly, and I know you've all heard this, she testified that she specifically observed that there was no carpet in the back of Zach's van on a date prior to May 17th. She specifically noticed that. So their theory that it was cut out at some later point. Now, I know that they say OA has a version of events about that, where now in retrospect she has focused in on that point after having met with the DA's office numerous times, and as she said, she's talked to so many people about what happened. When she described on the stand how she was having difficulty remembering what exactly happened, her explanation was that she's talked to so many people it's hard to keep track. We also heard from a number of different people that Zachariah Anderson has significant back problems. He's been experiencing them for some time. And I'd ask, how is it possible for a man that has a history of back problems to wrap up a large man the size of Rosalio Gutierrez into a carpet soaked with blood, which adds who knows how many more pounds of weight onto that, and somehow lift that person out without dragging it, by the way, Because if it had been dragged, there would have been a trail of blood. This would have to be someone who is strong enough and big enough to hoist a body rolled in carpet up over his shoulder or carry it out without blood being dragged out of the scene. How does somebody with back problems accomplish that? We also know that Zach was there at the property in Cedar Grove on May 18th doing work. His phone pinged there. And incidentally, later that day, he goes to pick up his taxes. Is this what somebody does when they've just murdered somebody the night before? Just going about doing normal things, normal business, normal work. Now, one thing about this case that is utterly hard to explain as to why this occurred and why law enforcement and the prosecution chose to not view this as terribly significant was this whole concept of geofencing. And we heard what that is. It's a little bit complicated, but it has to do with utilizing cell phone data from carriers and being able to give locations of people who may have gone to a particular location. So geo as in geographic, fencing as in a designated area. Who came in and out of this area in a given period of time? And we heard testimony that Detective Correa admitted he kind of made a mistake when he was looking at gathering this evidence because it simply came up with too many hits, too much to sift through, too much to really have any meaning. But it did reveal a number of people who were in the vicinity of Rosalio Gutierrez's apartment during the time frame that the state believes he was murdered and the days after. None of which were tracked down, none of which were followed up on, none of which were investigated. And at a minimum, even if this wasn't somebody who would have committed a murder, it could have been, but even if it wasn't, people that would have witnessed, heard, seen something. And why didn't they follow up on that? Because they had their sights on Zachariah Anderson and him alone. By the way, if, as Mr. Gravely says, Zachariah had really traveled to Kenosha to stake out the property, they would have been able to do some geofencing to determine that. In fact, if Zachariah Anderson had been at Rosalio Gutierrez's apartment on May 17th, they could have done geofencing to determine that as well. And that was not done. Frankly, people that we know it would be possible to track down people who were at the scene during the time in question, and it is utterly shocking that that was not followed up on. Now, Mr. Gravely didn't talk a lot about it in his closing, but he was very adamant to point out that there was all of this marijuana activity going on. And you've heard an instruction from the judge that talks about how that was admitted for a very limited purpose. And really the only reason that the state offered that was as it related to the cross-examination, or the direct examination rather, of Zach's girlfriend and how much she knew about all that. But in the process of that coming out, we saw the photograph of the many, many bags that are claimed to be soil left over from some sort of marijuana growing operation. And if you look at the picture, they appear to be the same black bags that were purchased at Walmart. One thing Mr. Gravely is forgetting when talking about somebody going to the bank and taking out cash is that, according to his own evidence, if there's this drug activity going on, which again, that's only for the purpose of impeaching or the credibility of a particular witness, wouldn't it make sense that it was somehow involved in the drug growing that Mr. Gravely wants you all to know about? Now, if he took the money out to flee, why didn't he? Why is he still doing normal stuff and hanging around, picking up his taxes and working at a job site 2 days later and 3 days later? We heard no evidence that he was trying to purchase plane tickets or packing things up, getting ready to go. saying his goodbyes to people, no evidence of any planning. If that money means that he was on his way out of town, why didn't he go? It makes no sense. We also heard about the GPS tracking items, and I'll point out these things that were looked up on Amazon and these actual GPS trackers, there wasn't any evidence produced that they were actually used at all. He's asking you to guess that they may have been because they weren't found. Now, Mr. Gravely brought out testimony from Marquand, Washington, about how GPS items can be used to track packages. Now, if this is one of the details that he says only someone who would have confessed to Marquand, Washington would know, I'd suggest to you that the expert on transporting drugs in this case is Marquand, Washington. He's an aficionado at being a big-time drug dealer, so that adds nothing to the credence that he has. Now, for the ease of explanation, I'd like to go through a summary of what the electronic evidence shows in this case. This is the timeline for May 17th. We know that at approximately 7:42 p.m., Zach Anderson's phone pings in Mequon. That's the starting point. At 8:24 p.m., Neridia Macias texts Rosalio that she's leaving her house, and we know that the trip takes 37 minutes. At 8:33 p.m., Rosalio texts Sadie saying he's going to Mike's. At 8:49 is when the phone call between Rosalio and Kim Lavora starts, and we hear that that was a rather lengthy phone call. At 9 o'clock p.m., and remember, there was two different versions of this. At one point, Lene Douglas said she heard a scream on a different date, but when she changed it to say that it was this date from apartment 1B, the time frame was approximately 9 p.m. Also, 9 p.m. was the time when Neridia was supposed to meet with Rosalio. At 9:01 p.m. is the logical time when Neridia would have arrived, which is 37 minutes from 8:24 p.m. At 9:06 p.m., the phone call ends, and Verizon records establish that Rosalio's phone is at or near or in his apartment. And at 9:24 p.m., we see that Rosalio's cell phone is unlocked. At 9:43 p.m., Neridia Macias texts Rosalio she was there, and there's no response. At 10:10 p.m., Neridia calls Rosalio for the last time and gets no response. Then we see at 10:10 p.m., there's the landscape change from Rosalio's cell phone. At 10:18 p.m., Neridia Macias leaves. Between 10 and 11 p.m., Marissa Swanigan hears a loud thump. It's closer to 10 p.m. At 11:19 p.m., we know that Zach Anderson's phone pings in Mequon. So a couple things about this initial timeline. First of all, we heard the testimony from Neridia Macias about how when she went to the scene, she went to go meet up with Rosalio. She went there, she waited, she tried to call him, she tried to text him, and she wasn't getting a response, and she waited there for quite some time. And in her initial statement that she made to police, she talked about the fact that that was how she remembered things going on. Many, many, many months later, Mr. Gravely went out to the scene with her. And after that meeting, after they had a discussion about what happened, Ms. Macias then came to the conclusion that she must have been at the wrong address. And we showed you information about the fact that on an Apple phone, it can take you one place, but on an Android phone, it has the capacity because of Google Maps to take you to a different location. But remember, Neridia at the time took a photo, a snap, of an Apple Maps direction that took her right to Rosalio's house. So, incidentally, the fact that Mr. Gravely thinks that because somebody is not doing anything on their phone between 7:42 and 11:19 makes somebody guilty. God forbid you turn your phone off, you're recharging it, you put it on silent, or you take a nap. Yeah, don't do those things because you'll look guilty. Let's look at what happened on May 18th. At 12 a.m., we know that Zach has a phone call with his girlfriend at Ping's in Mequon. At 4:18 a.m., Zach does a web search, looks for Lowe's, Menards, different hours. 4:19, another search, Home Depot hours. 4:58, Walmart hours. Again, remember, this is when some stores weren't even open. Stores that were normally open 24 hours weren't open because COVID had changed things. 8:17 a.m., Zach arrives in the parking lot of Saukville Walmart. 8:30 a.m., Zach leaves the Walmart parking lot. Then we see it pinging in Belgium at 8:45, 11:28, 11:41, and then by 11:48, it's pinging in Port Washington and Grafton. Again, it's pinging at 12:23 p.m. in Port Washington and Grafton. He does a search of the Milwaukee weather at 12:39 p.m. And then, depending on which version of statements that Lene Douglas made, her first statement was that she heard an argument coming from apartment 1B on the night of the 18th, not the 17th. At 1:30 to 4:15, Zach's phone pings in Mequon. And at 4:16 p.m., there's a Crime Stopper report. Somebody saw a white female with dark hair on Rosalio's patio. At 4:52 p.m., again, Zach Anderson phone pings in Menominee Falls. That's when he was going to pick up his taxes. Let's talk about some other things that are admitted into evidence. This is Defense Exhibit 280. This is texts that were between Sadie and Junior, who we know to be Rosalio Gutierrez. Sadie says, "Poppy, no snitch." Junior is saying to Sadie that he knows the address. 6813 Highland Road, Mequon. That's Zachariah Anderson's address. Further down, they're talking about from Rosalio to Sadie, "I don't want to make things worse for you. I just wanted to make sure if it's still the same price." Sadie says, "Thank you for that." Junior says, "For the record, only if you say it's okay." Further down, Sadie says to Junior, "What texts?" Junior says to Sadie, "Then delete those texts from your phone." Further down, Junior says to Sadie, "That's what I'm going to do. I've already reached out to old friends. I could be hands-free from this situation." Defense Exhibit 281. Junior's talking to Sadie. "No, he can't be shitty to you either." Sadie says to Junior, "Like he can be shitty to me, but he has no reason to go after you." From Sadie to Junior, "If some chick did that to me, I'd go check that shit too, honestly." Kind of saying it's not any big deal. Sadie says to Junior, "That crosses your boundaries." Sadie says, "I'm out of it now." Junior says to Sadie, "There needs to be consequences for his actions." Junior says to Sadie, "I care about you and don't want to cause more problems, but I think I'm going to pay him a visit." Rosalio says to Sadie, I want him to know exactly who beat his ass up. Rosalio says to Sadie, he can have all my info. From Rosalio to Sadie, I'm not worried about it. So Sadie says to Rosalio, I'm effing pissed he removed your personal information from your car. Rosalio says to Sadie, really, I'm not worried or questioning. Rosalio says to Sadie, Ava found it the other day when she was riding in the back seat. Junior says to Sadie, LOL, I have no clue and don't really care, LOL. Let's go down to Junior. He has a letter from the last owner of the car, exclamation point. From Sadie to Rosalio, including this letter, so he definitely was here. Oh, and he says to her, LOL, that's funny. So that note was in the passenger side back seat pocket. Sadie says, and still has them. Or Junior says, and still has them. Then Sadie says, I wasn't sure what he was saying and why, but then Liv just told me he took something from your car. Then Sadie says, he took your vehicle registration and a note from DJ. When he left today, he said, you know that effer doesn't care about you. He really loves DJ. Then Junior says, did you record more? And here we go. On Defense Exhibit 279. Sadie tells Junior, Zachariah Anderson lives in Mequon. It's on Defense Exhibit 272. This is where Rosalio says, well, I guess if he has your information, you should I guess if he has your info, you should have his. That is a text sent to Rosalio from Sadie. So that gives us a flavor, and that's where we're talking about the interactions and who is being harassed, who's being afraid, and all those other things. Now, again, when we're talking about these burn pits, remember there were two that were looked at. There was no evidence tied to the crime in either location. There was some clothing items. There were no bones, no body parts, nothing, just some stuff that was perhaps from some clothing items. We know that from the testimony that more than one person would throw stuff into the burn pit, especially the one at Zach's house. And by the way, if you're going to burn evidence of a murder, why would you do it in your own yard of your own property? That makes absolutely no sense. And it also explains why they only found some remnants of some random clothing. Now, interestingly, when Mr. Gravely's talking about how odd it is, all these funny coincidences and all this lack of luck that somebody would have, he didn't point out the fact that when these two individuals came to Zach's house and they figured out where he was, and they said they were looking for Rosalio, that was the day when Zach called the police. If this happened after the murder, why would he do that? And that's something that a normal person would do when there's people coming on his property and asking questions and things. Let's talk about a little bit more about Marquand Washington. This is a guy that, by coming in, he's got absolutely nothing to lose and everything to gain. I know that Mr. Gravely told you that if it turns out he's lying, then he could get into trouble for that and there will be no deal. But let's use some logic here and let's figure out what he's doing here. He's testifying for the prosecution. He's testifying about something that he supposedly overheard. He is in a big bunch of trouble. And if he goes down on the charges that he has without doing something desperate to get out of it, he's going to have to do at least 10 years and maybe more. So who decides in that context whether he's telling the truth or not? People from the government, both the state and the federal government, have to get together in order to make this motion that we heard about. It can only come from a prosecutor in order to reduce the possibility of that 10-year sentence. So if Mr. Gravely thinks that Zachariah Anderson is such a conniving, plotting, careful, meticulous, well thought out genius of a murderer, why on earth would he be blabbing his lips in a jail cell to Marquand, Washington, when it just so happens it's a Christmas present for Marquand, Washington? Just so happens that is his get-out-of-jail-free card. Now, that's some incredible luck for Mr. Washington. Did you also hear the way that Mr. Washington described this when he said, "Die, die, die, MFer"? Sounds like something out of a movie or a TV show. It sounds silly, frankly, that someone would be in their sleep and they jump up and say, "Die, die, die." It sounds like a fantasy. He knows he's here hoping to reduce his sentence. Now, when we were selecting the jury and we talked about who's heard things about this case, most of you, or at least some of you, knew that there's been media coverage of this case. There's been details about the investigation. There's been details about what's been going on in all forms of media, print, news, etc. And there have been details in there that anyone looking at them could easily have gleaned enough information to be able to pretend that they had a private conversation with Mr. Anderson. We also heard evidence of the fact that there was this issue with the Discovery USB drives that were used at the jail, and that people would go and review the Discovery. And at one point, Mr. Anderson had reported it missing, and it later turned up under mysterious circumstances. It's easily the kind of thing that Mr. Washington could have looked at and could have incorporated into the, frankly, the minor amount of detail that he put into it. You know, interestingly, if this is such a strong case for the state, why did they have to bring in a jailhouse snitch that is, frankly, incredible, unbelievable, and adds nothing to their case? It shows the desperation on the part of the state to make this fit. Mr. Gravely talked about how these trackers, this whole theory that, hey, they didn't find it. They didn't find any trackers, so it must have been used to track. An absence of evidence, the lack of people finding anything. Well, there was no data or registration of any of those devices or any evidence of that uncovered in this very detailed investigation. He talks about, again, Mr. Anderson being off the grid and how unusual that is. He's making the absence of evidence seem like something significant. So if you're not doing anything on your phone, that's apparently evidence of guilt. He talked about this cell phone that, again, as he's revealing to you what he thinks the murderer would have been thinking, putting the cell phone into the freezer as part of this very elaborate scheme to cover one's tracks. Remember, there was evidence that there was a trace allele of DNA on that cell phone that we know does not match Zachariah Anderson. Mr. Gravely talked about how for OA that it would be impossible for her to say the same thing as she did in 2020. basically explaining away why there were these inconsistencies and why there were these changes in what she said. And I'd agree that there is something impossible about that. If you go through your testimony over and over again, meet with the DA's office repeatedly, it probably would be impossible to remember what you said back then, and your story probably would change. And another thing, that I heard Mr. Gravely argue that Mr. McAtee's lawyer was standing here in the courtroom, and when he asked if there was a deal, the answer was no, and that's correct. But what was being talked about was whether there was a completed deal, whether there was something that had been signed and put into place. What Mr. McAtee was talking about was that there was an attempt to see if he would be willing to cooperate. And what he did is he came in here and said he's not. Now, Mr. Gravely also portrayed this process whereby Zach would have had to go down to Kenosha, commit this murder, do a bunch of things, wrap a bunch of stuff up, get it out of there, and hightail it back to Mequon just in time to immediately talk to his girlfriend and say, sorry, I was having a nap. If it was done that quickly, and if there was an expediency involved, where he had to get back to make sure that his so-called alibi, as Mr. Gravely likes to call it, he certainly would have passed by places where there would have been video surveillance. If he's trying to go the quickest way, not take back roads, whatever he's trying to do, there's been, in spite of a massive search of any evidence, that Zachariah Anderson went to Kenosha on May 17th, looking at all possible sources of evidence. There is none. And the only explanation for that is that he went off the grid. Now, another thing that's interesting about this case is that we heard Mr. Gravely talk about stuff that Zach said during the course of law enforcement people talking to him, and they were saying, what car do you normally drive? Which one is, how many cars do you have? And he's saying, he was saying all these things that were misleading. Well, was it misleading to say that there are two cars that are driven and that one is an Audi and one is a work van? And we didn't hear a recording played of how that actually happened. We didn't hear a body camera. We didn't hear anything specific about how it was worded, how the question was asked, how it was answered, or what they were specifically talking about. But to make it fit so that it appears that he's trying to be disingenuous, it's just sort of repeated that way. Folks, this is not a case where we should be relying upon possibilities or conjecture or guesswork. We have the highest burden of proof that exists in the world applicable to this case. That is proof beyond a reasonable doubt. And this is exactly the kind of case where that burden is so very important. We heard about the massive amount of effort and resources that were put into investigating and prosecuting this case. All of those resources are at the disposal of the government. We did hear some issues about how, well, it got to be burdensome or a bit time-consuming or hard. They put limits on how many items we could process, so that's why we didn't do everything. I guess that's understandable, but in a case of this significance, you'd wonder why. But the burden of proof being so high is important because in our society, in our country, in these United States, before anybody's freedom is impacted by a criminal conviction, it must be when the government produces evidence that rises to that very high level. And in the process, must eliminate all reasonable hypothetical possibilities. All. This entire case is built on possibilities and a series of what-if questions. And it's an assembly of guesswork. And the tragedy is that the real killer has not been caught. If, in fact, Rosalio is dead. Now, again, the way that this works is that if after hearing everything and after you go through your deliberations and you have discussed your view of the facts and what the state has or has not proven, if you come to the internal conclusion that it's possible that Zachariah Anderson may have committed these crimes, that means not guilty. Possible means not guilty. If in the process you come to the conclusion that it's very likely.
Objection. This is not proper argument about what the different scenarios are. You can talk about the instruction, but not conclusory words and what they would mean, and if they're not in the instructions.
Common sense, Judge.
Well, the difficulty is with the scope of the word possible. If you can reconcile the evidence upon any reasonable hypothesis, which is consistent with the defendant's innocence, then you must do so and find him not guilty. Go ahead.
And that pretty much summarizes where I was ending up with this, and thank you, Judge, and that's precisely what the law is. So if it's looking a certain way or if it feels a certain way, that's not how this works. And there's another instruction that deals with you are not to base your verdict on sympathy, emotions, or other things that stray you from an objective look at this evidence. And when you do that, there is only one logical conclusion as to all of this evidence that has been presented after this long process of presenting everything to you. Zachariah Anderson is not guilty.
Thank you, Mr. Robert. You have a maximum of 10 minutes, Mr. Gravely. Ms. Krizarek.
10?
I told you before we started how long was available, and I'm not singling you out. I told everybody.
My best.
And I said the division doesn't work out if you talk more than 75 minutes, and Mr. Gravely talked for 95.
Talk for a little less than 90, but Judge, I will get it done.
Thank you.
Growing up in Wisconsin, my mom used to always tell me, if you hear hooves, think horses and not zebras. And that's what this case is. For parts of the defense's closing, it appeared we had watched and listened to 3 weeks of a different trial. Because what you were essentially told is that DNA is not DNA, and you should disregard it for a reason I'm still not sure of. Let's be very clear. We heard from 3 separate people from the crime lab. I got a little fatigued with the number of crime lab people who came to testify, and they all said the same thing. I am a professional. This is what I do for a living. My specialty is either in DNA testing, or it's in crime scene collection, or it's in peer reviewing other people's DNA testing. And they all gave you the same opinion to a reasonable degree of scientific certainty. What was found in that van was blood. We zoomed in on it. To a layperson, it also looks like blood, but to 3 professionals, it's blood. Doesn't look like any other form of DNA. And that DNA belonged to Mr. Gutierrez Jr. They could not have been clearer. There was no hesitation. There was no but and X, Y, and Z. It was, this is DNA, this is blood, this is the victim's blood. So let's clear that up right now. There was absolutely no other way to hear that testimony from 3 witnesses with over 70 years of experience. The next thing I want to talk about is this whole theory potential of Mr. Gutierrez was going to go mess with the defendant's stuff in some way. Number 1, there is no message regarding doing anything to a van, a truck, a car, anywhere. So when Mr. Robert cites that, it doesn't exist. Look through all the messages. It doesn't exist. But number 2, and more importantly, the state proved to you through GPS that the victim was never, Mr. Gutierrez, was never at the defendant's residence. He did Google or put into the Waze app the residence and look up where it was. But when he was doing that, his GPS has him at his home for a 12-hour period. He was never there, which means his DNA was never there, which means no one messed with any vehicle of the defendant's. So that explanation for this DNA also doesn't hold water. They talked briefly about Olivia Anderson and the daughter, and why she can't be believed, or why she shouldn't be believed. But what you saw her do up there was, I think, the toughest thing she will probably ever be asked to do, which is to come into a court in front of a bunch of strangers, but more importantly, in front of both of her parents, and tell some of the worst things she's ever been asked to do. Say words like, I was my father's spy. He would have me record my mother, and he wanted it when she was angry or there was an argument going on. And she tells you those things not knowing about all of the digital evidence we've reviewed. And that's what's important here is she gives a statement May 19th, and she talks about these different things. Being his spy, looking through the windows, dad is recording, all of these pieces. And then the digital evidence backs her up every single time. Are there recordings on the defendant's devices? Yes. MSI laptop, 36 at least. 36 recordings, and they're a collection of, according to evidence, collection of the defendant and Sadie Beecham arguing, Olivia recording some arguments that are going on, and the defendant and Olivia talking regarding different things going on. So she tells you something, she declares it, evidence backs her up. She talks about work boots. She talks about all of these pieces that are then confirmed in the actual evidence that was presented to you. And the same with Sadie Beecham. Sadie Beecham tells you on the 19th, in her first interview, he's tracking me. I found a phone on May 8th, and he was tracking it. She doesn't know that we're going to go into the MSI laptop and find snapshots tracking her from Oak Creek all the way to Mr. Gutierrez's apartment. She has no way of knowing that. What she knows is what happened to her, what she found, she reports it, she's confirmed. Same with May 13th. She tells you, convincingly, that he was tracking because he literally repeated to me what Mr. Gutierrez had just said. So on May 19th, when she says that, she has no way to know that what we're going to be able to do is verify with phone records, verify with cell tower data, verify with his GPS directional things we find on the G6, that he did indeed track her down from Mequon, arrived in Kenosha, and was sitting outside of Mr. Gutierrez's apartment when she makes that claim. So when we look at believability and credibility, we have to look at what is backed up by the evidence. And every single time, the daughter, Sadie Beecham, and all of the digital evidence on Mr. Gutierrez's phone is backed up by what the complaint is here. There was some talk, briefly, about how Miss Beecham wasn't harassed in some way by what the defendant was doing. I don't know how she could have been clearer in the different recordings you heard, in her testimony, in essentially all of her text messages. But the recording that spoke to this the most was the one from April 25th. So it's later on in the afternoon after she finds out the defendant has violated her home in the way he had, videotaping her through curtains. The recording that I played for you said, Sadie Beecham, I told you, and this is in regards to breaking up, I told you, I was honest about it. You don't want to hear it. You want to hear it a different way. That's what this case is. This whole, God, were they, won't they, will they get back together? It's very clear. They were never getting back together. Sadie Beecham was done, and the defendant wasn't. And he was losing control and jealous, which was, I think, also reflected by almost every piece of evidence presented via the text messages. She wasn't texting him the emotional ones about, oh, I love you, oh, I miss you, oh, all of these things. That was all him. That was his jealousy, his loss of control, which manifested into an obsession with both Miss Beecham, but in this case, more importantly, Mr. Gutierrez Jr., because in his mind, that's who was breaking up their family. The defense talked about how, well, no, they were open and honest with each other. The defendant and Sadie, no, open and honest. She was in a new relationship. They talked about it. No, they didn't. She didn't want to talk about it at all. She told you. The only thing she ever told the defendant about this relationship was essentially that she had a friend. That was it. Other than that, the name, what they would do, when they'd be getting together, literally everything else was stolen from her by following her, by using the daughter as a spy. She didn't tell him any of that voluntarily. And you heard her say that. It's backed up by the messages. So this whole, gosh, we were both moving on and it was so great, not borne out by any of the proof. There's also talk of how it's normal that when someone in your life is seeing someone new to do these little things. And I think to a certain extent that could be. If you wanted to CCAP, your ex-girlfriend's new boyfriend, sure. I guess that could happen. You want to look him up on Facebook, also could happen. I think you might even get away with, I just wanted to confirm that maybe she was really moving on, so I drove by the house and saw someone else's truck. Sounds like a bad country song to me, but I think you probably get away with it. What you don't get away with is taking it those steps further. Bringing your daughter with you in the middle of the night to her mother's house. Getting out of the vehicle when you see another vehicle there and approaching the house. Recording the activity. None of those things are anything other than stalking behavior. And we have it here many different times in many different ways. And the only definition for this is stalking. Sadie Beecham was more than harassed by what the defendant was doing because he wasn't just watching her, he was taunting her. He would watch something, he would then contact her about it. Every moment she had from April 1st on with Mr. Gutierrez was always clouded in, is he also watching this? Is he listening right now? No moment between the two of them was ever their own because the defendant was always there. And that was the point. He was interfering with her relationship even if he wasn't there. That is stalking. The question was then asked, was Mr. Gutierrez really being stalked because he had some anger towards him? But I submit to you, on the night of May 17th, when this defendant showed up at his house and blitz attacked him and struck him with a blunt object at least 6 times, that Mr. Gutierrez, without a doubt, felt harassed, felt tortured, felt fear for his life, and it's something he ultimately paid for with his entire life. So to say that he didn't have these experiences, these emotions, is disingenuous, but also not based in reality. He was murdered by this guy simply for having the misfortune of being the first guy that his ex-girlfriend moved on with. The timeline here becomes really important because it fits. We know it takes just about an hour to get from here to Mequon, and we know that the last time anything has been done with this phone, when it's set on its side, is 10:10. It gets him back to Mequon. It gets him back in touch with the world in every way that matters. If that was the only piece of evidence we had, I think we would be in trouble. But when you add that to the stalking behavior, the jealousy issues, the verified time that he had previously been to the victim's home, and everything else, it's one more checkbox that fits. It's one more thing that corroborates every witness that testified regarding who is the perpetrator in this case. There was talk about the defendant not having injuries. Well, it was a blitz attack. It's pretty clear that that attack started in the hallway. I don't know what anyone expects Mr. Gutierrez to have been able to do when he's hit immediately upon his door opening and at least twice out in the hallway, and then at least 4 more times in his residence. It's a blitz attack. This wasn't a fair fight. This wasn't, let's meet at the corner and fight this out. That's not what this was. This was, I will lie in wait, I will knock on your door, and as soon as you open it, I will carry out my plan, which is to murder you. Mr. Gutierrez didn't have a chance. So the fact that he didn't land a blow or didn't somehow scratch the defendant, especially if he's wearing gloves, matters not. He did not have a chance. You saw a Walmart video. It was pretty obvious that it's pouring rain, as it was kind of hard to see at times with it coming into the camera lens. But the defendant did park incredibly far away from the door, in the pouring rain, in the way that's been implied. And I think that does matter, because what does he have to hide? It's what's in the van. What is left in that van that hasn't been cleaned up yet? There was talk of what he purchased and how it was COVID. He didn't care about COVID. He was, first of all, walking around Walmart without a mask, so clearly step one. But further than that, you saw his house. I mean, it wasn't exactly well kept, we'll say. This wasn't a place that was routinely being Clorox wiped or cleaned or organized in some meaningful way. These were specific tools he needed at that time to take care of a specific problem that was still in that van. Just one more check mark of the fact that you know the defendant is responsible for this. there was a little bit of talk, and I'll briefly cover Susan Brown Williamson. When she mentioned carpet on the stand, I think you saw the surprise from a certain table in this courtroom, because that was such a focus of our case and in terms of talking to her. And that's something obviously she had never offered before, given the surprise. But here's what's more crucial. Not that it was a new piece of information, but that what she said was not that that piece in the back was gone. She said all of the carpeting was gone, which once again you know is categorically not true based on pictures. So it's yet another witness who offers up something that they've never said before, but that one's not backed up by anything because you've seen the van. You know exactly that suspicious piece of carpet that's missing. So her now inventing a new reality about the carpet being gone makes no difference because how she represented it was all the carpet was gone, and we know that's not the case. Ms. Macias testifying. I don't think she could have been clearer. She went to the wrong building. She pointed it out to you, I think, probably 4 or 5 different times she was asked to get up. She showed you which building she went to. She talked about how she pulled in. She talked about where she parked. She came voluntarily to the police station. She gave them all of the messages she had. She did everything you would ask a citizen to do, and then she testified exactly what she did. And for me, the most telling thing, and I ask you to consider this, is when asked at the end of all of her testimony, now knowing that that's not his building, can you even pick out which one belonged to Mr. Gutierrez? She said no, because she never made it to his actual building. So is that someone who's lying, or is that where her GPS took her for the first time she had ever come to Kenosha to meet with Mr. Gutierrez? I submit to you it was pretty obvious that she was telling the truth, and all she ever tried to do here was answer the questions posed to her. That's not suspicious. That's just someone being a good citizen. Lastly, we're going to talk about burn pits just briefly, and then I will wrap it up, Judge. Burn pits by themselves are not suspicious. I agree with that. You know, people burn things. I grew up in the country, or you guys here call it the county, the country. We burned things, we burned wood, we burned different things at our house in terms of, fireworks, things like that. But it's in conjunction to what is going on in this case that makes it suspicious. 7 inches of rain fall over a 3-day period. And in this fire pit that's still smoldering to the point that the fire chief has to come and help put it out, or the deputy chief talked about the remedial measures they had to take, was everything that you would need to get rid of to try to cover up a crime in these circumstances. Bleach. Well, we know bleach was used in the car. You saw the stains. You have clothing, specifically jeans, at least 1 pair, potentially more than 1 pair, which, as Mr. Gravely indicated, makes sense here because you both murdered someone but then also had to clean up that scene. Socks, underwear that match yours, steel-toed boots, which that's not something that I've ever heard of being burned before, but apparently it can be done given what's in the fire pit. And that's why it's suspicious. Having a fire pit's not suspicious. What you're burning in the middle of a rainstorm is. You're getting rid of evidence you never expect to be found. So in totality, what we have here is a defendant with the means, the motive, and the opportunity to commit this murder. He's the only person that was even talked about in this case that had any sort of motive against Mr. Gutierrez. And Marquand Washington was actually the one that gave it to you the cleanest way. Sadie Beecham was happy. Mr. Anderson was pissed because Sadie Beecham...
Don't use that language in the court.
I apologize. Because Sadie Beecham was happy. You saw Becky cry, her friend, Becky Jekyll, cry about how happy she was for her friend to have moved on. And that was what made her emotional when she was talking about Sadie Beecham finally finding something that was positive, and it was making her happy. And that's what the defendant couldn't stand. So what I'm asking you to do is consider all of the evidence here, focus in on both the physical evidence, the DNA specifically, because there is no explanation for that should have any doubt in your mind that this defendant murdered Rosalio Gutierrez, and he needs to be held accountable for that. I ask that you return guilty on all verdicts. Thank you.
Thank you, Ms. Kozarek. Members of the jury, the time has now come when the great burden of reaching a just, fair, and conscientious decision in this case will be placed wholly with you jurors selected for this most important duty. You will not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence I charge you to keep your duty steadfastly in mind and as upright citizens to return just and true verdicts. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdicts are matters for me alone to decide and must not affect your deliberations. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal and not a civil case, and therefore, before you may reach a verdict which can lawfully be received, it must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That presiding juror's vote is not entitled to any greater vote than that of any other juror. If you need to communicate with me while you are deliberating, you must send a note through the bailiff which has been signed by the presiding juror. You must communicate only by a written note. If you have questions, I will speak with the attorneys before answering, so that may take some time. In that event, you should continue your deliberations while you await an answer. I will answer any questions in writing, orally here in the open court, or by the speakerphone up in the jury room. When you have agreed upon your verdict, it should be signed and dated by the presiding juror. Would you bring the tumbler and put it before Mr. Anderson, please? He needs to draw one of the names out. Yeah. Take one out and show it to your lawyers, and then give it to the bailiff, please. And this juror will be excused. Can you go up and get it, please? Those are for the jury, yes. You can have a seat right there, if you would, please. All right, jurors, you may now retire to consider your verdicts. I beg pardon? Yeah, the bailiffs do. There's some tissue there, if you like. The statute says to dismiss you at this time. There have been some rare cases, but very famous cases, in which jurors who have been excused have been returned to the jury. That's, I don't want to create a sense that that's a likelihood, but it is a possibility. And for that reason, if you'll continue with the injunction that you not discuss the case with anyone, or read what your list to any account of the trial, we'll keep you on call if you can leave a number with the bailiff, and we'll continue your princely rate of pay as long as you're available, and we'll notify you if and when a verdict is reached, or otherwise ask you to come back. Any questions? Okay, thank you very much. And I apologize that you put in a lot more time than expected, and then, all right.
Judge, you have to swear the bailiffs.
Thank you. Where is the other bailiff?
You want us to be seated?
You may be seated. Do you and each of you solemnly swear that you will keep all persons sworn on this jury together in some private and convenient place, subject to the court's direction, and that you will not speak to them or permit anyone else to speak to them concerning the state of their deliberations or the verdicts upon which they have agreed? So help you God. Thank you. All right. Discuss the exhibits, and if you can reach an agreement, just put it into the record. And it's unlikely I would disapprove of it, but if there's any dispute, then you can, the clerk has my number and can call me. Sorry, I have to dart out of here.
Thank you, Honor.